Please, my lord.
Yes.
I am there for the appellant.
Okay. Okay.
Please, my
Yes,
lord.
Mr. Singh.
Please, my lord.
Yes.
My lords had kept this matter for some. Uh, my lords can hear
So,
me.
today is fixed for furnishing the certificate.
But we have already filed that certificate, my lord.
Okay. When?
My lord,
Your Lordship, we have filed it 2 days back, which has come on record, Your Lordship.
Record.
Yes, Your
Have
Lordship.
you furnished a copy to Mr. Mazumdar? You got it? Anything to submit? Nothing. Okay. We reserve it for judgment.
I'm so grateful, my lord.
Or Mr. A. Singh, learned counsel for the appellant, and Mr. Mazumdar for the respondent. Judgment reserved.
Grateful, my lord.
Items for motion, item number 3.
Wait, volume to your sense for 9. Video pending.
PTR may be required, Lordship.
LCA.
PTR may be required, Lordship.
LCA.
Lordship.
Heard Mr. Soria, learned counsel for the accused, and Mr. Bartakor for the respondent. This application under section 483 of the BNSS 2023 is prepared by accused, who has been languishing in jail azut in connection with session case number 66 of 2025. Arising out of Rongia PS case number 149 of 2025. Under section 103 within cat 1 of BNS 2023. Since 18/7/2025. The learned counsel for the accused submits that after completion of investigation, the IO has filed charge sheet against the present accused, and as such, the TCR may be called for. Accordingly, it is provided that a recessal call for the TCR fixing the matter on
13th August.
13.
Deeply blessed. 11th August. Item 4.
May I please, Lordship? This is regular bail application, Lordship. Offence is under section 303-317 BNS. BNS, Lordship. Accused are behind the bar since 21/6/2026. As on today, 44 days, Lordship.
What is the punishment prescribed for section 303?
3 years, Lordship.
3 years.
3 years, Lordship.
And under section 317?
It is also 3 years.
3 years.
Yes, Lordship. Section 303, subsection 2, Lordship. Can I read, Lordship?
You are behind the bar for 46 days.
44 days, Lordship. as on
44
today.
days. What is the allegation?
Page 20 is the
28,
page 20.
20. Okay.
Component of the mobile tower in the and the total battery of 60,000. And from there, position goes. So the article is over.
Lordship, kindly see
You
the
are
FIR,
the
Lordship.
you are the owner of the dam.
No, Lordship. No, Lordship.
Hmm.
I'm not the owner. Owner is Atwar Ali,
Hmm.
Lordship.
Then why you have been arrested?
Lordship, what happened in this case, Lordship? Lordship, kindly see, turn to page number, Lordship, 14. Page number 14, Lordship.
Hmm.
Contents of the first information report, Lordship.
Hmm.
Can I read, Lordship?
Hmm.
Page number 14, point number 12. First information report content. On 17/6/2026, complainant Sri so-and-so stating that a reliable source information was received that a scrap dump situated at Lokra under the jurisdiction of Gorchuk police station was allegedly keeping and dishonestly receiving suspected stolen articles on its premises.
Hmm.
Acting upon the said information, a search was conducted at the premises. During the search, two persons, namely Sabibur Uddin, son of so-and-so, and Sanidul Ali, Sanidul Ali, 19 years, son of so-and-so, Assam, were found present and apprehended for verification. But they were not involved in this instant case. Main fact, what is the main fact of this case, in Lordship?
Hmm.
Prior to 4 days of the incident, the accused number 1, who is aged about 36 years, joined the dam and with his family members. The accused number have five minor sons, five minor children, Lordship. They joined the dam and they were working there. And on the day of incident, he was sleeping in the cottage, which was provided to the dam owner, to the petitioners, as well as other employee of the
Okay,
dam
okay.
owner, Lordship.
Mr. Bhattakur,
Accused number,
you say is behind the bar for last 44 days.
44 days.
Punishment is 3 years, up to 3 years.
Yes, otherwise, our probably covering report and FIR is not discernible by the owner, but from there, this one only those who again, so I can put this. Yes, yes,
Hard, Mr.
and I can, Lordship.
Learned counsel for the applicant, accused person, and also hard Mr. Bhattakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is prepared by accused. So, Sabibur Uddin and Anidul Ali, who are languishing in jail in connection with Gorchuk PS case number 140 of 2026 under section 302 within 303 within bracket 2 313 of BNS 2023. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by S.I. Kusal Deka of Gorchuk Police Station. The essence of allegation against the present accused person is that they have received stolen articles and 18 pairs of aluminum fixer component used for connecting RRU unit of telecom tower, 1 RRU remote radio unit box used in a telephone tower, and 1 CP plus NVR model number CPUNR 4K4322-V3, 12 volt DC were recovered from their possession. The learned counsel for the accused submits that the accused were arrested on
17/6/2026.
on
17/6/2026.
17/6/2026 and forwarded to Zelazot on
18/6.
18/6/2023, and since then they are behind the bar for last 44 days. He also submits that the punishment prescribed for the aforementioned offences is up to 3 years, and that further further custodial detention of the accused person may not be warranted in the interest of investigation, and accordingly it is contended to allow them to go on bail. However, Mr. Borthakur learned additional PP has opposed the petition on the ground that some articles of worth rupees 60,000 were recovered from their possession, and that the city may be called for fixing a short debt. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record. And it appears that the accused were forwarded to judicial custody on 18/6/2026, and they were arrested on 17/6/2026. They are languishing in jail as of for last 44 days, and that the stolen articles have already been recovered and seized by the IU, and in that view of the matter, their further custodial detention, in the interest of investigation, seems to be not warranted, and accordingly, this court is inclined to allow this fix. It is provided that on furnishing amount of rupees 25,000 each on furnish a surety of like amount to the satisfaction of the Lord Exis and Congressman, both the accused be enlarged and break.
May I please your lordship? In the 483 application, I take your lordship to the FIR at page 11, my lord. Page 11, my lord. May I read, my lord? With
What
due
are the
respect-
section? 25(1)(a).
But my lord, it is a suspected that whatever, my lord, I am a driver. My car was hired from Boko. And my lord, they suggest that they are coming to near Kamru, my lord, Changshari. My lord, my vehicle was parked in a little distance. The occupant came out.
Mr. Biswas,
Yes,
see,
Preparation
section
for recording
27
and
is also
arms
there,
act.
arms act.
yes.
Let the city come.
My lord, one thing, the FIR was occurrence taken place on 23/5. FIR was lodged on 23/6. And interestingly, my lord, I take your lordship to the forwarding report, what it reveals, my lord. Kindly take little pain to peruse it, my lord.
No, we'll go through the same after perusing the case there. Let the city come.
My lord, one thing, how the investigation was done, I'm telling kindly. Page 17 for 1 minute.
No, how investigation is carried out,
Page
that will
17, what I
be,
has written, my lord.
pardon?
On 23/6 was complained, namely, Avida lodged a FIR that Changshari PS stating that the one night of 23/6, 23 June 26. But FIR, according to FIR, it is 23/5. And I was specifically time and again writing 23 June. Heard the sound of the gunfire near their residence and rushed outside to find out the gathering local people. Two co-villagers of Rakib Ahmed and Ritu Jawan, who were returning home from work, reported that they had personally witnessed the two unidentified youth attempted to illegally trespass into the informant house. Upon being spotted, The two miscreants opened fire to create terror and fled the spot. Shortly, they boarded the waiting gateway vehicle registered number such and such. So I was the driver, but I do not know that what they are doing. But suddenly it is reported that after 1 month FIR was lost. 38 days I am behind the bar.
Okay, we will see. Let the city be called for fixing the matter.
Changshari Malat.
Sorted.
Fifth.
মেল কৰিছিলে কালি ৰং ইমেইল আইডি পঠাইছিলে VC ৰিকুৱেষ্ট এতিয়া ৰিকুৱেষ্ট কৰি আছে পাৰ্মিশ্যন দিব ফৰ্মেটো কাৰেক্ট নহয় ৰং ইমেইল আইডি Item 6.
May please your lordship, kindly pass over the matter for the time being. The arguing counsel is on legs.
Who will appear?
N. Kalita. Oblige, your lordship.
Item 7.
May it please your lordship. Here, on the page 13 is the FIR, my lord. Whatever, my lord. Here, my lord, there are a series of cases lost by, my lord, the informant's family against the petitioner's family and petitioner's family against the informant's family, my lord. Here, petitioner was granted pre-arrest bail in a different case. He went to the police station, then he found that one case of 2025 was pending against him, and in this case, he was arrested.
How many cases are pending?
Okay, that's it. But in some of the cases, those are fixed on 4th, my lord.
On
On 4th, my lord.
4th of August. CD has been called for.
Yes, my lord.
CD.
for consider. CD, my lord.
Heard Mr. Abdullah, learned counsel for the accused.
Weak.
And also heard Mr. Borthakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused
এখানে মনে থাকে নাকি?
Abdul Mintu, alias Mintu Ali, who has been languishing in jail as in connection with Dibrugarh PS case number 189 of 2025 under section 118, which will make it 2/189, which will make it 2 of the BNSS 2020 BNS 2023 since 21/7/2026. Mr. Abdullah, learned counsel for the accused, submits that in connection with some other bail applications, the case diary has been called for fixing the matter on 4th of August.
Right.
What is the number?
My lord, BA number 1938/26, BA number 1939/26.
And as such, this application may be tagged with those application and may be disposed of after perusing the case diary. Accordingly, it is provided that Resi shall take this matter along with BA number so and so, and on receipt of case diary on 4th of August 2026, an endeavor will be made to hear and dispose of this petition after perusing the case diary.
Oblige, my lord.
Item 8.
May I please, your lordship. This is a regular bail application registered under section 21B and 29 of the NDPS Act in connection with Proceed 61 of 26 North Gauhati PS case number 51 of 26. Arrested on 16/6/26. Proceed FIR is at page number 13. Type copy of FIR.
50?
84 grams. Intermediate quantity.
From the joint of the public ballot,
8 and 9. Proceed already 45 days.
40?
45 days. Proceed.
42 days,
45 days. Proceed.
45 days.
Or
Or CD? Is it necessary? See the lady?
Already.
Asmina Parvin.
We've already 45 days and completed 45 days. And she has minor signs sorted.
Maybe, but one thing we have to see whether she is habitual in this matter or not.
No, Lordship. She is not a official offender, Lordship. there is no earlier criminal antecedents on our part.
Heard. Mr.
Yes, Borga.
Learned counsel for the accused and Mr. Portakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused Asmina Parveen, who has been languishing in jail hazard in connection with North Gauhati PS case number 61 of 2026 under section 21B and 29 NDPS Act since 15/6/2026. Is to be noted here that above noted case has been registered on the basis of one FIR lost by one Jagriti Doimari, SI of Police, Polasbari PS on 15/6/2026. The essence of allegation against the present accused is that she was found in possession of 84 grams of heroin in 6 soap boxes on 15/6/2026 at about 11:15 AM. You are from Murshidabad of West Bengal.
Meherun Nisa is the another petitioner. She is from West Bengal. Asmina Parveen is from Borpeta, Lordship. And there are item number 8 and 9. Both are raising out of same FIR. And Lordship, from Meherun Nisa, no, the drug has been recovered, Lordship, from her possession.
But they were traveling together.
Yes, Lordship.
We'll see the case there. Let the CD be produced before this court on
7,
short date.
8, 7,
It will come from Borpeta,
not Gauhati.
Not going to PS, Lordship.
not Guwahati. Short date. 4th of August, 5th of August. This matter and the other item,
8 and 9, Lordship. Item number 9.
8 and 9.
8 and 9. Oh, let.
Item 10.
May I please your lordship?
Mm.
Lordship, petitioners before your lordship are father and the 2 sons, my lordship. My lordship, annexer 1 page 13 is the FIR, my lordship. There are total 27 persons named in the FIR. Page 13, my lordship.
Mm.
Total 27 persons named in the FIR. Along with it, it is written 30/40 unknown persons, my lordship. So, my lordship, petitioners are not named in the FIR. May I read the FIR, my lordship?
Mm.
So it was a case of assault in which specific some persons have assaulted my lordship, the informants. And as per my information, they are already released from hospital, my lordship. So on the basis of these 30/40 unknown persons, my lordship, and because of some religious political agenda also, my lordship, petitioners are searched. Petitioner number 1 is a retired school teacher, my lordship. Petitioner number 2 is a doctor, my lordship. And petitioner number 3 is a pharmacist, my lordship. And each petitioner number 2 and 3, they have CCTV cameras in their own respective clinics, my lordship, which will prove that at the time of the occurrence, they were not in the place of occurrence, my lordship. My lordship, here they are not named in the FIR. They are being searched along with other common persons of the village, my lordship. I have annexed the iCard also of petitioners, my lordship. Petitioner number 1 is the retired school teacher, my lordship. Petitioner number 2, he is a my lordship, practicing Ayurvedic medicine and surgery doctor. And petitioner number 3 is a pharmacist, my lordship. My lordship, actually, it was with regard to collection of revenue, and it was something political, my lordship. I will not go to that aspect, but my lordship, petitioners are innocent and they are not involved, my lordship.
So what are the punishment for the offenses?
Yes, my lordship,
Under which the case has been registered?
amongst this, my lordship, 303, my lordship, subsection 2,
Mm,
my lordship, it comes at 326, my lordship.
mm. Punishment is life.
No, my lordship, 303, subsection 2, my lord.
What what's the
303, subsection 2, my lordship. No, some which will not be less than 1, but which will extend to 5 years and with fine, my lordship. And okay.
one
Life is 113, 1182.
Okay, let the city come.
My lordship, they are innocent, my lordship. I have
We'll
specifically,
see you
my
are
lordship,
whether you are innocent or
my
not.
lordship, I have specifically made paragraph, my lordship may even include that in order. I have specifically written the CCTV footage I can submit of the pharmacy, of the clinic where I was attending patients, my lordship.
No, why should we consider your
No, my lord-
CCTV footage that this is this?
No, my lordship, I can submit to the.
If there is any
granted an
CCTV
opportunity,
footage
my lordship.
seized by police, then we may see it as
No,
it.
my lordship, here I am, my lordship, my submission, only a submission, my lordship.
Mm.
Specifically, they have mentioned 27 persons, my lordship,
Mm.
specifically. And along with it, they have written 34 unknown persons, my lordship.
Maybe.
And my lordship may kindly consider they are not such that they had no past antecedents, neither any criminal record. My lordship, they are educated family of the colony, my lordship, who has one is a retired school teacher, other two petitioners are also educated, my lordship. They are no way connected, my lordship. I will cooperate with the investigation, my lordship. I may be protected with an interim order, my lord.
And informants are public servant.
No, my lordship, they are the tenderer, my lordship, bazaar collecting tax, my lordship.
whether this is a case of my lord religious case of other religious or my lord the genuine case of my lord accounting thereafter my lord previous injury also the only city will reveal
My lordship, I'm aware of that part, but my lordship may kindly consider. I have no past antecedents. This family,
Maybe we will say from the case diary.
my lordship, that
CD on when? 5th of
My-
August? 7.
my lordship, 7 August. My lordship may kindly, my lordship, there's a 15 August is the my lordship CD. My lordship may make an observation, prayer may be considered if the case there is not available on next day. Only
Let
this
us
much,
say
my lordship.
on that day we may consider your
My
prayer.
lordship, because that day my lordship
no,
might
no,
be
no.
busy and my lordship might.
No.
My lordship may kindly make an that if CD is not, because my lordship may kindly see that these petitioners' names are not there.
No, he will produce the case diary.
27 persons, my lordship, specifically named, my lordship, and these are, they are retired teacher and my lordship, all doctor, and if they are arrested, my lordship, everything will be ruined, my lordship. They are not named.
We'll say.
And even the injuries also not reflected, my lordship, and even
No,
they are released.
therefore, Bortakor CD along with the medical report of the victims.
5th August, obliged, my lordship.
But this case, FIR is at page 13, my lord. The present petitioners are the family members of the main accused, my lord, the husband, my lord. Allegation is registered under section 82, my lord. Dowry death, my lord.
Death.
Dowry death, my lord. And the husband, my lord, he has already been arrested, my lord. He is in judicial custody, my lord. And the present petitioners, my lord, they are the family members, parents and elder brother, my lord. They are living separately from the accused number 1, my lord. And interestingly, my lord, the victim lady, my lord, as well as the main accused, my lord, they are having a child, my
PM
lord, 3
report,
years child, my lord.
PM report and the case diary be called for fixing the matter on Bortakor.
But, kindly see the page number, my lord,
Sort that.
page 8, my lord, paragraph number 16, my lord. Kindly see it. Page 8, paragraph 16, my lord. There is a minor
No, that
baby.
is your statement only.
Yes, my lord, there is a minor baby, my lord, 3 years old, my lord.
Maybe.
From the FIR itself, my lord.
Hmm.
And the baby, my lord, is with the petition number 3, my lord, his grandmother, my lord. So that at this stage, my lord, they may be protected, my lord. Otherwise, my lord, the minor baby will.
TD and the PM report on
Yeah, my lord, 11 months.
sorted.
11 age. 10 age.
Obliged.
My pleasure, Your Lordship. Lordship, FIR is page number 8, Your Lordship. Victim is Major, Your Lordship. I manage the admit card of the victim. Age is 19 years old.
They collected. Not
CDN medical report of the victim.
Lordship, page
fixing
number
the matter
14,
on-
Your Lordship. I have annexed the marriage document, Your Lordship. I have applied for the marriage under Special Marriage
We'll
Act, Your
see,
Lordship.
we'll
Put
see
into-
whether, what is the age of the victim?
19 years.
We'll see.
Page 13, admit card. And FIR also is mentioned 18 years, Your Lordship. Now,
See
material
the-
title, Your Lordship, both the parties
see
that
the
decided to marry
statement
the victim,
under
Your
section
Lordship.
183.
Both the party decided to solemnize the marriage, Your Lordship. In the meantime, may I pray for some
Sorry.
protection, Your Lordship.
Sorry.
Already applied, Your Lordship, on 17 July, Your Lordship.
Can it be 10th or 11th? 10th of August. 10th of August.
I pray for some protection.
TDN Bartakur, there's a medical examination report of the victim
Yes.
and 183 statement.
Pending item 6.
Obliged.
6.
Here, my lord, petitioner was arrested on the 22nd of this month, my lord. My lord, on allegation is that, my lord, he posted a, my lord, hatred post in the Facebook on 21st of July 2027. FIR is at page 12, my lord. First paragraph itself, my lord, says, my lord. Petitioner is a veterinary doctor, my lord, and his father is also doctor, MBBS. And my lord, post, my lord, that particular post I have annexed. Lordship will find at page 25. Print copy, my lord. During that protest or at the Jantar Mantar by my lord, CJP, my lord, he was also influenced and out of emotion, my lord. But he has no intention. He has done nothing, my lord.
Bartakur?
9 days behind the custody, my lord.
From the contents of the parable, he stated about the names of three and thereafter he wants to express it in that sense.
But 152, my lord, may not be attracted, my lord, because my lord, he has not done anything to my lord, substantiate his that post. He has got a lesson, my lord, for his, and lordship knows.
Heard, Mr.
NK Kolita.
Learned counsel for the accused and Mr. Bartakur learned additional reading for the state respondent. This application under section 483 of the BNSS 2023 is prepared by accused Nipun Talukdar, who is languishing in jail resort in connection with Pachala PS case number 71 of 2026 under section 152, 153, within bracket 2, BNS 2023, since 22nd of July 2026. Notably, above noted case has been registered on the basis of one FIR lodged by one Ishur Kumar Sharma, ASI of Police, Patsala Police Station, on. When the FIR was lost? 22nd of July 2026. The allegation against the present accused is that he had uploaded an objectionable, inflammatory and provocative post on his Facebook account expressing his desire for a situation similar to the recent incident in Sri Lanka, Myanmar, Nepal, and Bangladesh to occur in India. Is this full post or you have edited it?
No, no, my lord. This is the full. No, this is the full proof. The above,
Mr. Polita Learned Counsel for the accused submits that the accused was arrested on 22nd 7 2026 and for last 9 days he has been languishing in jail Azut, and that he is a veterinary doctor and his father is also a doctor, and though the case has been registered under section
152 and 353.
152 stroke 353 within bracket 2 BNS, the same may not be attracted in this case, and that he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. Barthakur, learned additional PP, has opposed the petition. By having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record and also perused the Facebook post uploaded by the petitioner in his account, which is annexed with the petition as Annex 5 at page number 25. The said post read as under Sri Lanka, Myanmar, Bangladesh, Nepal. Same situation হোৱাটো অন্তৰৰ পৰা বিচাৰো, নহলে আৰু ডেমক্ৰেসি গুচি ডিক্টেটৰশিপ হৈছে। Having considered the submission of learned counsel for both the parties and also the tone and tenor of the language used by the applicant or used by the accused in the aforementioned Facebook post, and further the period of detention, this court is of the view that further custodial detention of the accused may not be required in the interest of investigation, and accordingly it is provided that on furnishing a bond of rupees 20,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate Pachala
Bozali, my lord.
Bozali, the accused be enlarged on bail in terms of above this BS then closed.
Obliged, my lord.
May I please, Your Lordship. Here, my lord, I am partially aggrieved by an order, my lord, whereby although I was discharged from all charges of the criminal cases, but battle nuts which are seized from my residence, those were directed to destroy because those battle nuts are not fit for human consumption, my lord.
So
I'll say-
TCR has not yet been received.
Yes, but this year not yet.
It is from Amin now, my lord, and it's the second death, my lord.
Heard. Mr. M.A.I. Hussain, learned counsel for the petitioner, and Mr. Borthakur, learned additional technique for the state respondent. Office note dated 29/7/2026 indicates that though reminder for scan copy of TCR was issued, the same has not yet been received. Accordingly, it is provided that registry cell urgently call for the scan copy of the TCR from the learned court bill, fixing the matter on 13 minutes.
13.
17.
My lord, this matter will be taken up for some time.
Why?
My lord, my learned senior counsel can see
What is the matter?
the quashing of FIR and entire proceeding. my lord.
When it was registered?
FIR, my lord. He started on 6/8/2025.
Almost a year over.
And
Then you were approaching this court after 1 year.
no, my lord, thereafter he was arrested, then he approached this on court, then charge sheet, my lord.
So today we will call for the record, or let the record
My
come.
lord, in presence of my senior, my lord, because
Pardon?
after some time, my lord. Obliged.
Wait, please, Your Honor. 528 application for recalling of non-billable warrant.
On what ground?
Uh, The warrant was issued as because on the last day, the accused petitioner was absent in the court.
What is that impugn order?
Impugn order is at page number 28, annexary. Start-seated method. After receiving of the summons, he had appeared before the honorable court. However, on the next day, he was absent. On the first day, he was present through his counsel. The case is at the initial stage, your lordship, and
So on that day, you remain absent without any stay.
without any steps.
Then what wrong with this order?
He will appear before the honorable court. I'm praying before the honorable
No,
court for recalling of the non-billable warrant, and he will appear before the
No, this is
learned
not,
trial court.
no, in a routine manner, we cannot recall it. You have to show the justified reason why you could not appear on that day.
Your Honor, I've mentioned in paragraph number 6, your lords, page number 5. On that day, due to my ill health, I informed my counsel that I won't be able to appear
No,
before the
your
honorable court.
counsel submitted before the trial court that you have not cooperating with him.
Yes, your lordship, but I have informed the learned counsel that due to my ill health, I'll be unable to appear before the honorable court.
And
There-
where is the
however-
document to show that your health was not good on that day? Where is the medical document?
No medical
No
document.
document. Yes, Portago?
Your lordship, if the
Better you go and file an application before the learned trial court. Enclosing the relevant documents for which you could not appear on that day. And on furnishing such on filing such application, the court shall consider the same in accordance with law. Heard, Mr.
JK here.
learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. In this petition under under section 528 BNSS 2023, the petitioner has challenged the order dated 22nd of June 2026, by which the learned trial court, by which the learned Subdivisional Judicial Magistrate M. Naharkotia has issued non-bailable warrant of arrest against the present petitioner for remaining absent without any state on 22nd 6 2026. The learned counsel for the accused, for the petitioner submits that the ground for failing to appear before the learned trial court on that day is mentioned in paragraph number 5, and that on account of ill health,
Paragraph number 6. Your Lordship.
paragraph number 6, and on account of ill health, the accused the petitioner herein could not appear before the learned trial court, and the petitioner herein has reported the matter to his counsel. But in spite of the same, the learned trial court has issued non-bailable warrant of arrest against him. He also submits that the accused is petitioner is ready to face trial and will appear before the learned trial court on next date, and therefore he has contended to recall or kept the warrant of arrest issued against him abeyance till his appearance before the learned trial court. On the other hand, Mr. Borthakur, learned additional PP, has opposed the petition. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the order dated 22nd of June 2026. It appears that in the said impugned order, the learned trial court has recorded that learned defense counsel verbally submitted that the accused Tinku Ali has not cooperated at all, and hence court may take necessary step to secure his presence. And thereafter, the learned trial court has issued warrant of arrest against the present petitioner, Tinku Ali. Though the learned counsel for the petitioner submits that on account of ill health, the petitioner could not remain present in the court, yet no such medical document is enclosed with this petition. Under the given facts and circumstances, this court is of the view that the impugned order dated 22nd of June 2026 suffers from no irregularity or illegality requiring any interference of this court. However, the petitioner is directed to appear before the learned trial court with a petition to recall the warrant of arrest enclosing relevant medical documents, and on such petition being filed by the petitioner herein, the learned trial court shall consider the same in accordance with law. In terms of above, this petition is disposed of in the motion stage itself.
Mathavis.
Wait, please, Your Lordship. Lordship, this is an application under 528 of BNSS, Your Lordship. It is for quashing of an FIR under 498A, Your Lordship. Lordship may come to page 26, Your Lordship. FIR. This is the copy of the FIR, Your Lordship. Page 26. Lordship, in the entire FIR, there is no particular of any event that has happened or any avert action on the part of the petitioner, Your Lordship. May I read the FIR, Your Lordship?
Not necessary.
Yes.
Let the
Lordship,
record
furthermore-
will say.
Lordship, furthermore, on page 28, there is a affidavit that has been given by the respondent number 2, Your Lordship, and that she wants to withdraw the FIR. But and the FIR is of the year 2023. Meanwhile, in
Page number
24, Your Lordship.
24.
Affidavit is on 28, Your Lordship. The content is on 29. Lordship, after the filing of the FIR, a kid has also been born, Your Lordship, in the family, and ever since 2023, they have been cohabiting together, Your Lordship.
Hmm?
And Your Lordship, the birth certificate of the child is on page 34, Your Lordship. The child was born on 25/12/2023.
Okay,
And
let the
for-
record come.
Lordship.
Will stay the proceeding till then.
Yes. Yes.
Heard, Mr.
D dekha, Your Lordship.
Learned counsel for the petitioner. Mr. Portaco, learned additional MP for the state respondent. This petition under section 528 of BNSS 2023 is referred by the petitioner for quashing the FIR dated 18/8/2023. Upon which this poor PS case number 1608 of 2023 is registered under section 498A of the IPC. And also for quashing the contemplated proceeding initiated therefrom pursuant to the registration of the FIR dated 18/8/2023. Where is the petition and the documents placed on record? At what stage the case is pending? Proceed submitted? No.
No, Lordship. No notice, Lordship, notice under 35(3) has been issued, Your Lordship.
Okay. It also recently submitted on 25/3/26.
Okay. After hearing learned counsel for both the parties, it is provided that Mr. Portaco shall produce the case diary before this court on 24th August. The learned counsel for the petitioner referring to page number 30. No, referring to annexure 3 at page number 32. Submits that the petitioner, no, the respondent number 2 is not willing to pursue the FIR dated
18/8.
18/8/2023. And to that effect, she has filed one application to the officer in charge, Dispur Police Station. And accordingly, taking note of the submission of learned counsel for the petitioner, till next date, further proceedings, no, further inquiry of this PS case number so and so is then state. Also issue notice to the respondents returnable on 24th August. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Portaco entered appearance and received notice. But
Obliged.
extra requisite copy of the petition will be furnished to him during the course of the day. This recording.
Obliged.
Item 20.
Made to your lordship. Well, this is a question for the special case number 104 of 2025, pending in the court of special judge Gauhati matter. Madam, earlier one of the queries approached this honorable court, and the coordinate bench of this honorable court already state the proceeding. So I pray, madam, matter may be taken with this matter, madam.
Pardon?
Madam, this case may be taken with this criminal petition already. This honorable court, my lord, granted stay of the proceeding. Set of it.
And this matter may be taken along with those two matters.
I have annexed also, my lord, this order, page 78.
So against the same search it.
Same search. Same set of allegations.
I have mentioned the criminal petition number. I have mentioned the criminal petition number. And then I would two cases, those two cases are pending. This matter may be taken along with those two matters.
Heard Mr. Ziuddin, learned counsel for the petitioner, and Mr. Dotto, learned additional public prosecutor for the state respondent. This application under section 528 of the BNSS 2023 is preferred by accused. No, preferred by the petitioner. Two petitioners, namely Baladev Sinha, alias Baldev Sinha, and Alimuddin Tapadar, for quashing of search sheet number 27 of 2025 dated 27/11/2025 and special case number 104 of 2025 arising out of vigilance PS case number 01 of 2028 registered under section 120B 420 406 468 471 406 409 IPC read with section 13(1) A struck 13(2) of the Prevention of Corruption Act and the proceeding of special case number 104 of 2025 pending before the Court of Learned Special Judge Assam. Let notice be issued to the respondent. Returnable when the next date is fixed in the other two matters.
Yeah, 4 weeks.
4 weeks is
After
mentioned.
4 weeks. However, no formal notice is required to be issued since Mr. P.P. Dotto entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Mr. Dotto, learned counsel, learned additional PP has pointed it out that another two criminal petition being criminal petition number 939 of 2026 referred by one Sahidur Alam Laskar and another criminal petition being 882 of 2026 filed by one Mohsin Ahmed Laskar are pending before this court and in criminal petition number 939 of 2026 by the order dated 25/6/2026, a coordinate bench of this court was placed to stay the proceeding of vigilance PS case number 1 of 2024. Hmm? And this matter may also be taken with the aforementioned petitions. Accordingly, it is provided that recess shall take this petition along with criminal petition number 931 of 2026 and 882 of 2026. And lays the matter after 4 weeks.
All right.
Item number 48. Copy of this here on earlier court.
My lord, in this case, my lord, a complaint was lodged, my lord, in the month of April in the year 2022, my lord. And complaint, my lord, can you see page 13, my lord? This complaint, my lord, the section which inflicted and subsequently CS was filed, my lord. And that complaint, my lord, it is a breaking of relationship between two families and nothing else, my lord. My lord, may I read this complaint? Page 13. Date of occurrence, my lord, 14/4/2022. May I read, ma'am?
So you are challenging the order dated 4/6/2026.
Yes, my lord. My humble prayer, my lord.
Where is that order?
Order, my lord. Page 30, my lord. Page 29 and 30. On receiving my lord summon, I approached before the learned session judge for anticipatory bail, my lord, which was not accepted. Because of that, my lord, I approached before your lordship. In fact, my lord, there is no case at all against me.
So at first, bailable warrant of arrest was issued against you. And despite execution of the warrant of arrest and releasing you on bail, you have failed to appear before the trial court, for which non-bailable warrant of arrest was issued against you.
Not trial court, my lord. The case was not committed yet. It is
Hmm.
before the magistrate, my lord.
Yes,
CS was
the
filed.
Chief Judicial Magistrate has issued a non-bailable warrant of
warrant,
arrest against
yes,
you.
Because I have filed anticipatory bail application before the learned session judge, which was not accepted, my lord.
No, that is a different aspect.
My lord.
Here you are challenging the order dated 4/6/2026.
My lord.
So it appears that you have been arrested and released on bail.
No, I have not. I was not arrested. I have not appeared yet. I have not appeared. Because of non-appearance, this admittable.
Have you gone through the impugned order?
Page 30, my lord. BW returned after execution, but the said accused person not the turned up. Issue and BW.
So bailable warrant of arrest returned after execution. What does it mean?
That does mean, my lord, that
Could you follow the meaning of that sentence?
yes, my lord. But in fact, my lord,
Then
I
what
have
wrong with this order?
and the last order, my lord, page 30, my lord. And BW issued. In fact, my lord, I have not appeared, my lord. I approached before trial court session judge for anticipatory bail, which was also rejected, my lord. Thereafter, my lord, that was issued. So
Or Thakur?
Otherwise, well, there is no option for him. He has to stand. Otherwise, he has to again file.
for a moment, my lord, kindly see this case, my lord. What is against me, my lord? There is
No. We are testing the order
Right.
dated 4/6/2026.
yes, ma'am. 4620, it is saying that BUW after execution, but I have not appeared, my lord.
Where you have not appeared.
Because, my lord, if the case is under non-bailable section, if I appear, my lord, I may put in custody. So there was apprehension, and for which I approached before the runner session just for anticipatory bail, by your filing anticipatory bail. That order I have annexed, my lord. Page,
Perhaps you could not follow the meaning of this order.
this is right, my lord. It is seen that after execution, but I have not appeared.
Where you have not appeared.
My lord, kindly see page 27.
No, where you have not appeared.
If I appear, my lord, I may put in custody.
He was already granted.
He do not understand the meaning of bailable warrant and non-bailable warrant.
If we granted to him, they have to appeal this appeal to the question of my lord and BW. My lord. There is-
My lord, kindly see page 27.
So, at first, bailable warrant of arrest was issued against you. And despite execution of the warrant and non-bailable warrant, you have failed to appear before the trial court, for which you have failed to appear.
Yes, my lord.
The
PW issued, but thereafter against NBW issued.
Why should we not dismiss this petition with heavy cost? Hmm?
My lord, for example, sometimes instruction may be taken from the client, my lord. Sometimes clients has.
No, you yourself do not understand what is
This is
bailable
right,
warrant
my
of
lord.
arrest and
It is-
non-bailable
It
warrant.
is said after execution, my lord, appears for which that is execution is done, my lord, PW. But on the next date, my lord, NBW issued, my lord. So now,
Yes, what wrong with the court? What wrong with this order?
so now, my lord, I have apprehension. If I approach, my lord.
You face your consequence, face the consequence. In spite of execution of the bailable warrant of arrest, you remain idle.
My lord, my humble submission, my lord. Now there is an NPW against me, lord. I have
Mm.
appeared, I have apprehension, my lord.
Mm.
And anytime I may be arrested.
Yes, you may be arrested. You tell this court why you should not be arrested.
My humble submission, my lord, in this case, my lord, the case, in fact, my lord, no offense I have committed, my lord, even on perusal.
No,
of the
no,
complaint,
we are not on merit of the case.
my lord.
You are challenging the order. You have to demonstrate from the record that the impugned order is illegal or arbitrary.
Not illegal. I am seeking only bail, my lord. I am not challenging this. I am seeking only bail, my lord. A
So
proceeding will be
whether
granted.
under this provision, this court can grant you bail.
For which, my lord,
Hmm?
I have filed another bail application also, my subsequently.
No, you tell me whether under section 528, read with section 482 of the BNSS 2023, this court can grant you bail.
In 482, my lord, your lordship can, in 482, my lord,
Can grant bail.
my lord.
You produce any authority before this court? We will list the matter on Monday.
My lord.
After hearing learned counsel for the petitioner and Mr. Borthakur learned additional PP, it is provided that learned counsel for the petitioner shall produce any authority before this court in respect of the power of this court to grant the petitioner bail in exercise of the jurisdiction under section 528 and 482, 528 of BNSS 2023 and 482 of CFC. List accordingly on Monday.
This along with AB number 1/666/26.
AB number?
Also, my lord, file one, the AB anticipated application also file one.
That was fixed, my lord. TCR was called for. my lord.
1/666, my lord, /26 with AB number.
Later on, Mr. Borthakur submits that the petitioner has also filed one anticipatory bail application being petition number
1/666.
and the same has been fixed on
My lord,
It was 11/8, my lord.
11/8. Registrar shall take this criminal petition with the aforementioned anticipatory bail application.
1/666/26.
11/8. 11/8.
On 11. 11. Obliged.
Your lordship, by office note dated 29/7/2026.
SP count.
Lordship, by the office date number 29/7/2026, neither AD card nor unserved notice nor any service report has been received back. Further, the case record, including order for framing of charge, evidence of witnesses as called for, has not been received. So, service report may be awaited.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner, Mr. Borthakur for the state respondent. Office note dated 29/7/2026 indicates that service report is still awaited. Service report upon respondent number. Respondent number 2
Respondent number 2.
still awaited. List the matter after 2 weeks awaiting service report upon respondent number 2.
And also reminder may be issued for trial court record. That has also not been received.
The said office note also indicates that case record, including order framing of search, evidence of witnesses, has not yet been received by the section till date. Rest shall issue urgent reminder to the learned trial court for transmitting the aforementioned record.
Deeply obliged.
May I please, Lordship? That means criminal appeal as well, IA also, Lordship. The
Criminal appeal?
IA is for, Lordship. I is for suspension of impugned judgment and order
So
dated
you have been convicted under section?
under section 21C.
Hmm?
21C and 29
For
for 10 years. Lordship.
10 years.
And rupees 1 lakh rupees, and in default of to undergo simple issue for 6 months. And today is the 2 years, 11 months, 22 days, Lordship. And before the conviction, the petitioners were granted bail, Lordship, and the liberty was not misused by the petitioners, Lordship, at that time. And ample grounds are there also, Lordship. Yes, sir. In section 42, 52A, and stock witness is there. Caesar witness is one of the Caesar witness is the stock witness, Lordship. Calibration certificate was not produced.
So service in this matter completed. You are representing the respondent number 2 also.
But
And the PCR has been received.
TCR received, my lord.
Let us fix a date for hearing and final disposal of the matter. Heard, Mr.
Rahman.
Learned counsel for the appellant, Mr. Osho for the respondent. Office note dated 21/5/2026 indicates that LCR has been received. And the matter is ready for hearing, and accordingly it is provided that Resist shall list the matter on 27th of August. Along with IA criminal number 309 of 2026, and on that day an endeavor will be made to finally hear and dispose of both the matter.
Okay. May I please, Lord? Appeal, my lord. Yes, for excellent. And in interim application for bail, I have filed my. Already more than 7 months in jail.
So, Kabir, that the appeal, whether the appeal is ready?
I come to the record, my lord.
There is material improvement, my lordship, from the FIR and the subsequent statement of the victim.
So you have been convicted for how many years?
My lordship, 7 years.
7 years. So trial court record has also been received.
Yes, my lord.
We can finally hear.
For final hearing, my lord.
Heard, Mr.
Yes, please.
Learned counsel for the appellant. Mr. Boisho for the respondent number 1.
Yes.
And you for respondent number? Respondent number 2. T. Parasor for respondent number 2. Learned amicus for the respondent number 2. It appears that this year has already been received and service has also been completed and the matter is ready for hearing. Accordingly, it is provided that registry shall list this criminal appeal along with IA criminal number 397 of 2026 for final hearing and disposal on
10 September.
10th of September.
What is it?
Highly obligement.
Lordship, it's a I for delay condemnation of 21 days as on 13th of July 26.
How many days?
21 days, Lordship.
'21 or 27?
13/07/2026, July, this month.
No,
No, 21 days delay.
21 days.
There may be my lord, 27 days mentioned in the file.
You have filed this application.
Lordship?
This application is filed by you.
Yes, Lordship.
You do not know
No,
what is the exact date.
Yes. Correction goes. It was corrected by the filing
Section.
section, Lordship.
Section. What is the ground?
It is explained in the paragraph 3, Lordship.
Paragraph 3. So you are appearing as a legal aid counsel.
Yes, Lordship.
Okay. Heard means N. Hassan, learned counsel for the applicant and Mr. Boysto for the respondent, opposite party. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 27 days in preferring connected criminal revision petition against the order dated 31st of March 2026 and 17th of March 2026. Passed in criminal in which proceeding these orders were passed. 13/3/2026 and 17/3/2026.
Lordship, actually the petitioner's father was connected with an NDPS matter. So the vehicle the vehicle is used in that matter was chased. And the scooty was belongs to the petitioner of this criminal revision
No,
petition.
no, these two orders were passed in which proceeding?
No, his first petition is in for Jimma. That was allowed. But there was allowed was on condition of 50,000 of bank guarantee in any nationalized bank. So he filed another petition for reviewing to minimize the amount because he is a student and he is unable to pay the amount. That review petition was rejected. That was the two
What is
petitions.
the number of that case where the petition was rejected? Special N case number 15 of
15 of-
2026.
yes, Lordship.
Okay, in special N case number 15 of 2026. The learned counsel for the applicant submits that the applicant is a student pursuing masters in Bodulan University, Kukrazar, and he has filed an application before the Secretary, District Legal Services Authority, Dorong Mongoldoi on 8/4/2026 to file criminal revision petition against the order dated 31/3/2023 and 17/3/2026. And then the Secretary, District Legal Services Authority, Dorong Mongoldoi, has sent a letter to the Secretary, Gauhati High Court Legal Services Committee on 8/4/2026 for filing criminal revision petition against the order dated 31st of March 2026 and 17 March of 2026. And she has been engaged only on 3/6/2026. And as she was busy in some other legal aid appeal matters, she could not prepare the revision in time. And in the process, delay of 27 days occurred. And the same is not intentional and no, rather it is circumstantial, and therefore she has contended to condemn the same. Mr. Boyso, any objection? Mr. Boyso, learned counsel, the learned additional PP for the opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also the explanation so forthcoming for the delay of 27 days in preparing the connected criminal revision petition. This court is of the view that delay of 27 days is sufficiently explained, and accordingly the same stands condemned. Accordingly, this IA stands disposed of. In view of the order passed in the IA, now the registry will register the criminal revision petition and list the same before the court as soon as practicable.
May I please, your lordship?
Yes.
So 122 days delay in filing the review petition. Lordship. Against the order 24/2/26 passed by your lordship.
Let notice go.
Lordship?
Let notice go.
Notice go, lordship.
Third, Mr. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condemnation of delay of 122 days in preferring connected review petition against the order dated 24th February 2026, passed in CRP IO number 331 of 2025. Issue notice to the opposite parties returnable in 4 weeks. To be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Obliged.
For their hearings, item 24. Ma'am, here, charge sheet has already been submitted yesterday as informed by my learned.
Yesterday,
Yes, yesterday.
it is under section.
Section 13(1) of the Assam Preservation Act. is there.
Session travel. Case is session travel.
Lordship, Sessions Tribunal.
Heard Mr. Bora, learned counsel for the accused, Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma apprised this court that after completion of investigation, IO has laid charge sheet.
Madam, charge sheet number 76 of 26. It is 33007.
Accordingly, it is provided that registry shall call for the scanned copy of the TCI.
We'll approach this jurisdictional court, Lordship.
Pardon?
We'll
You will
this
approach the
jurisdictional-
trial.
Yes, yes, Lordship.
Is there any interim order?
No, Lordship. This is a bail application, Lordship. BA.
BA, okay. However, Mr. Bora, learned counsel for the accused, submits that since charge sheet has been submitted, the petitioner will approach the learned trial court for bail, for granting bail, and this application may accordingly be closed. Accordingly, taking note of the submission of learned counsel for both the parties, this application stands closed,
Lordship. Much obliged.
granting liberty to the petitioner to approach the trial court by filing appropriate petition.
Lordship. Much obliged.
I agree, your lordship.
Madam,
My lord.
here scan copy received, madam. They have also received the madam.
Service report,
Service is also completed, my lordship. Sir, flag hai.
21/7.
service report received. Today we have to engage one amicus. Heard Mr. Loskor, learned counsel for the petitioner, Mr. Sharma, learned additional PP for the state respondent. Office note dated
21/7.
21/7/2026 indicates that service report in respect of service of notice upon respondent number 2 has been received, but no one entered appearance till date. In that view of the matter, who can be appointed?
Madam.
Regular.
A Borua is also there, madam. Orindam Borua is also.
Yes,
A Borua, Orindam Borua.
Orindam Borua.
Is he regular?
Madam.
Mr. A. Borua. His name is there in the list.
Okay, serial number 70.
Mr. Orindam Borua, learned counsel, they engage as amicus to represent the respondent number 2. Rest shall reflect the name of Mr. Orindam Borua in the cause list and also furnish the relevant papers to him well in advance and list the matter on CD receipt.
Scan copy received, madam.
Scan copy receipt. I got it. 6 hours.
I'll leave.
26. My place, Lordship, 483 bail application, Lordship. I am on length of detention, Lordship. It is in my calculation in 90 days today, Lordship.
Madam, charge sheet submitted, madam. I have received the information, madam.
When?
Madam, charge sheet on 29/6, madam.
29/6. Yesterday.
No, madam, in the earlier month.
Oh, okay. In the month of June. Yes.
Madam.
29/6. Under which provision the case has been registered? Four.
Four.
So let the scan copy of the record come. Service report. Complete. Here also amicus has to be appointed. Suggest the name for amicus. Heard Mr. Soria, learned counsel for the accused. And also heard Mr. B. Sharma, learned additional VP for the state respondent. Uh, Mr. Sharma apprised this court that service upon respondent number 2 is completed, but no one entered appearance. And in that view of the matter, Ms. Vijita Sharma, learned counsel, is engaged as amicus. Registration reflect the name of Ms. Sharma in the cause list, and also furnish the relevant papers to her well in advance. This will also call for the TCR fixing the matter on when. Pardon? Okay.
Yes.
12 of August.
I thought 29.
This is an NDPS case, regular bail option, most probably charge sheet has been received. Charge sheet has been 29. Lord, TCR may kindly be called for.
Heard Mr. Putter, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma submits that though CD has been called for by this court by order dated 15/7/2026, yet in the meantime, the IO has completed investigation and submitted charge sheet. Accordingly,
Number 50 of the 26, dated 11/7/2026.
Accordingly, it is provided that recess will call for the TCR from the learned trial court, fixing the matter on.
Scan copy losses, most probably lots of scan copy of.
Yes, TCR. Scan copy of TCR. On or on.
Maybe on 10th August. Obliged, Lord.
And then 20.
May I please, Your Lordship?
Yes.
Lordship, the petitioner was arrested on 7/6/2026 and as on today, 55 days. Lordship will find the FIR, page 13 months,
Today's
55 days,
55 days.
60-day offense,
60 days.
60 days, man.
Maybe. With the allegation that the petitioners had stolen 4 numbers of cattle, they came to be arrested, and further allegation was that those cattle were supposed to be used for the
Oh,
purpose
how
of,
long you were behind the bar?
my lord, as on date 38 days,
38 days.
my lord. And that, we have purchased the cattle, to that
Mr.
effect,
Sharma, CD received. Is there any material against that? And what is the stage of investigation?
May I take your lordship to page number 32, That would be help in arriving at an opinion, Page number 32, that is an excerpt. This is the observation made by the learned judicial magistrate, while granting the Zimmer petition filed by on behalf of the petitioners. May I read, That I am reading the relevant part, The IO in his report, perused the report, page 32, Order dated 13/7/2026. Learned counsel for the Zimmer petition is present. Today is fixed for report on Zimmer of the 4 numbers of cattle filed by the petitioner. The report is called for, has been received from the IO today. Peruse the report. The IO in his report stated that the aforesaid cattle were seized in connection with this case, and the petitioner is the lawful owner of the said
said seized cattle. The IO further submitted that seized cattle are not required for further investigation of this case, and on verification of the purchase invoices, it was found that the seized cattle have been purchased from the Zahirpur weekly market and received produced by the petitioners are genuine in nature according to the market committee, and the said cattle are purchased by the accused petitioner.
Whether this report is part of the case diary.
This report is there, my lord. Even the market committee has also issued one certificate, Millard, that they are authenticating that, yes. In fact, we produced it.
verification earlier phase matter. Question put to the market earlier. Yes, question put to the market.
No, these are the questions. Where is the answers?
Next page. Next page.
Okay. Okay, we'll pass the order.
I don't know this also, gentlemen.
On any condition, we will be allowed to oblige.
Pending item 17. Wait, please. Lord, I'm filing for quashing of the proceedings, my lord. If your lordship would kindly come to the FIR at page 18.
Yes.
I'm reading from the first subpara that I was induced into a relationship by below noted named accused under a false pretext and continuous assurance of marriage. This relationship initiated around 2014 and continued until recently. Throughout the period, the accused repeatedly made solemn promise to marry me, and on the strength of these assurances, I was induced to enter into a physical and emotional relationship with him. At that time, I genuinely believed the accused to be committed to the relationship and future marriage. However, it has now become evident that the accused never intended to fulfill his promise. After gaining my trust, emotional attachment, and engaging in so and so on the basis of false promises, he has now flatly refused to marry me. In doing so, the accused has not only caused irreparable harm to my dignity. Anyway, my lord, it's basically they are trying to make out a case of section 81. Now, my lord, the police has submitted a charge sheet, my lord. Please have a look at page 25. And I'll also refer to one of the notice issued by here. Please come to page 25, my lord, part of the charge sheet. During investigation, it is found that accused had love affairs and accused solemnized his marriage with the informant on 5/2/14 by Kaji. During investigation, it further came to know that after marriage, the accused often developed physical relationship with the informant. Thereafter, when the informant demanded to lead conjugal life, the accused threatened her. During investigation, the accused was arrested and forwarded to judicial custody to the Honorable Court. During investigation, so and so, so and so. Now, my lord, if it was a marriage, then end of the matter. Now, my lord will kindly come to the legal notice issued by her. That is again interesting. Page 37. I, on behalf of my client, hereby issue this legal notice to you in regard to your failure to fulfill the terms of marriage agreement executed in the office of the Kaji situated at Hathigaon, Gauhati, on so and so, and your subsequent action, which had led to breach of our marital obligation. So, where is the criminal offense, Miller? Upon submission, Miller, where is the question of invoking section 81, Miller? If I have broken marital contractual provision, Miller, then the civil court is there to take care of it. Now, Miller, recently, Miller, Supreme Court has delivered one judgment, Miller, precisely on this point. If your lordship would kindly have this paragraph 27 and 28.
if I'm not paying alimony, if I'm not behaving properly as a husband, there are other forums, my lord. It's the question of criminality. If it is her case, my lord, that we were married in 2014, and thereafter, my lord, maybe they led their life as a husband and wife. Now to allege all these allegations, my lord, and the legal notice is very clear that you have violated the marriage agreement clauses. Therefore, my humble submission is, my lord, the continuance of this criminal proceeding is an abuse of the process of law. Now, in fact, para 2, they say, despite execution of the agreement and consummation of the marriage through physical relationship, you have failed to accept my client as your wife. One more aspect which I would like to emphasize, my lord. We never married her by using any deceitful means, my lord. That's not the allegation. That's very clear in this case. This is not the allegation that I applied any deceit, my lord, to marry her.
But one aspect has to be looked into.
Yes, my lord.
That is, your alternative remedy is there. You can file an application before the trial court to discharge you. But whether
Lord,
we will exercise this power while alternative
no,
remedy is
that
available.
that is true, my lord. But normally we find, my lord,
Hmm.
his court is very slow in exercising those powers, my lord. That's why at times we are compelled to approach your lordship.
No, in the event of
I cannot,
framing
on
search,
principle, I cannot dispute that proposition, my lord.
Mm.
But in practice, we find, my lord, hardly, my lord, the charge orders are issued, my lord. That's why otherwise, my lord, it is not the pleasure of any client to approach an higher forum, my lord.
Mm.
People would like to close the proceedings as early as possible. Let us also.
no.
And my lord, having regard to the attending facts and circumstances of the case,
Mm.
I think lordship will examine this matter, my lord, and lordship will give a look into the allegations, whether these are, my lord, are sustainable in the eye of law. It is in that perspective, my lord, we are before your lordship.
No, that's all right. But if somebody goes to the higher forum, then the
To be honest, my lord, once, my lord, these contradictions were noticed, I don't think, my lord, it was so mechanically even, my lord, cognizance should have been taken. Kindly see, my lord, the contradiction. Kindly look at the FIR, and kindly FIR speaks about something else and charge sheet is something else. Charge sheet speaks of marriage. If it is marriage, what is the wrong in husband and wife cohabiting? So therefore, my lord,
for causing the FIR, charge sheet and entire proceeding of PRC case number 129 of 2026. Arising out of SIPAZAR PS case number 134 of 2025 under section 81 stroke 351 within bracket 2 within bracket 3 of BNS. Pending before the Court of Learned Judicial Magistrate First Class, Dorong, Mangaldoi. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. Recessal call for the record from the learned trial court. Scan copy of the record from the learned trial court. So Chaudhary, learned counsel for the petitioner, referring to the annexure 4, an order dated 1/4/2026 submits that the learned trial court has taken cognizance of the offense of under section 81 stroke 351 stroke 2 stroke 2 within bracket 3 of BNS upon the search sheet submitted by the investigating officer, and the next that is fixed upon 15/6/2026. And further, referring to the legal notice dated 3 3rd of April 2025, annexure number 5, is submits that in fact, marriage was solemnized between the parties. And if subsequently any dispute arose between them, they could have availed the remedy provided for violation of the for breach of contract. Breach of contract. And referring to a decision of Honorable Supreme Court in the case of Soilas Bhai, Govindra Bhai, Makoana versus State of Maharashtra and another reported in 2026 Live Law SC page number 459 submits that in the event of solemnization of the marriage, subsequent having sexual relationship would not attract the criminal liability. And under such circumstances, he has contended that further proceeding of GR case number so and so pending before the learned JM first class Dorong Mangoldoi may be stayed till returnable date. The submission of Mr. Sudhuri, learned counsel for the petitioner, received due consideration of this court. And also this court has carefully gone through the petition and the decision relied upon by learned counsel for the petitioner. Taking note of the submission of learned counsel and also the annexure number, especially the annexure number 5, this court is of the view that a prima facie case is made out for staying further proceeding pending before the learned trial court, then accordingly till returnable date further proceeding of GR case number so and so stands state. List after 4 weeks.
Deep knowledge.
49.
Here regarding the 32, it is still trying to collect the report from the conference. I don't know. Yet to my
Today.
will try to also. It will get my
This is a bail application which has been filed, my lord. There are 3 to 4 grounds which I have filed the bail application. One of the foremost ground is that, my lord, section 47 and 48 had not been complied with, my lord. My lord may have the FIR first, my lord, which is at page number 18, my lord. My lord, if my lord may have it, the brief of the case is that today on 5/12/2025 evening.
You are referring to page number
18. Type copy. On 5/12/2025 evening, so and so of Manja Karbi Anglong so and so has lodged an FIR at Manja PS to the effect that today on 5/12/2025 morning at around 10 AM, a specific input was received from a reliable source that a white color car is coming from so and so, which is suspected.
No, you are not on the merit of the
No, I'm
petition.
not on the merit.
You are only for non-compliance of
Section 47, my lord. The Section 47 notice is at page number, my lord.
47 and
Section 47 first, my first ground, my lord. Then
and
section
next one
50 notice of NDPS has not been complied with.
50 NDPS.
Yes, my lord.
47 of BNS.
47 of BNS, my lord.
Okay. No, on the other day, I have raised the query as to whether compliance of section 50.
Section 47, my lord.
No, 50 NDPS Act can be considered at this stage or at the end of trial.
No, it was the query which had been raised, my lord. Your lordship was section 47 can be raised at the time of trial or not.
No, on the other day, I have mistaken. The section 47 as 47 of NDPS.
Yes,
It
section
is not
47 of
47.
BNS, my lord.
It is BNS.
BNS.
Yes.
So section, yes, it can be taken in the time of trial also, because, my lord, it has been placed in the judgment, my lord, in Mihir Rajesh, my lord, which I would like to give a copy. My lord, first, my lord, I would like to give a judgment of Vivan Kumar, my lord. It's 2025 5 SSC 799, my lord.
That is there, but a division bench of Allahabad High Court has held that
it has been stated that
Vivan Kumar decision is contrary to a decision of a larger bench.
No, there is no larger bill. Larger bill has been referred this time, my lord, in the Sonam Raghuvansh's case, my lord. The grounds of arrest, there was a dispute whether the ground of arrest has to be communicated or it has to be given in written, my lord. That has to be clarified by the larger bill in Sonam Raghuvansh's case, my lord. That has not been decided till now. But my lord, amongst the other ground, that the basic details of the facts should be mentioned in the section 47. My lord, may come to page paragraph number 26 of this judgment, my lord. In the concluding part.
Paragraph number
26, my lord. At page number 818, my lord.
Yes.
My lord, it has been stated that 26.2, which says that the information grounded must be provided to the arrested party in such a manner that the sufficient knowledge of the basic facts considering the ground is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of the communication must be such that the object of the constitutional safeguard is achieved. Then on, my lord, I skip the 26.3, 26.4, which states that non-compliance with Article 22(1) will be the violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to a personal liberty guaranteed by the Article 21 of the Constitution. Therefore, non-compliance with the requirement of the Article 22(1) vitiates the arrest of the accused, and further order passed by the criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet, and trial. But at the same time, filing of the charge sheet will not validate a breach of constitutional mandate under Article 22(1). Here, the charge sheet has been filed and the trial is going on. Now, my lord, I would like to place Mihir Raj's judgment, which is 2026 1 SCC 500, my lord. My lord, in here, my lord, the paragraphs are from 28, but my lord, I will not trouble your lordship to go through all the paragraphs. My lord, may come to paragraph number 31. Paragraph at 521 page, my lord. The relevant portion of Vihan Kumar is reproduced herein. I will be skipping that paragraph 20, 29. My lord, I will come to paragraph number directly to the portion 21 in 31, which is mentioned. An attempt was made by the learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and now a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such argument with great respect to the learned senior counsel will amount to completely nullifying the Article 21 and 22 of the Constitution. Once it is held that the arrest is unconstitutional due to the violation of the 21(1), the arrest itself is vitiated. Therefore, continued custody of such a person based on orders of remand is also vitiated. Filing of charge in order of taking cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21 and 22 of the Constitution of India, my lord. This, my lord, has come. Now, my lord, I would like to refer to paragraph number 70 of this judgment, my lord. Paragraph number 70. After considering the aspect of grounds of arrest has not been communicated within the 2 hours prior to producing the accused, my lord, on paragraph number 17, which says that the ground of arrest has to be provided as per the criminal appeal number so and so and criminal appeal number so and so are concerned, the court, while granting leave so and so, had by way of ad interim relief directed the appellant to be released on bail during pendency of this appeal, the same shall continue. However, the prosecution may move an application for remand of custody if required, along with the reasons and necessity for the same, after the supply of the grounds of arrest in writing to the accused before the magistrate, if the case has not been committed for trial, and in case the trial have been commenced before trial, as the case may be. So, my lord, my humble understanding and my humble submission is that, my lord, though the ground of arrest has not been, the plea of ground of arrest can be taken at the time of the trial, because the bail which was filed in the lower court was pre-trial, my lord. And that was not taken by the trial court, my lord, at the time.
Okay.
My lord, my section 47 has been cleared, my lord. Now, my lord, the other ground is that, my lord may peruse the FIR. In the FIR, it states that, my lord, on 5/12/2025, the person was restrained, my lord. And on the arrest memo, which is at page number 28, my lord, which at page number, my lord, 31, my lord, it states that on 6/12/2025, the person has been arrested, my lord. Now, my humble submission is that there's a discrepancies in the arrest, my lord. My lord, for that, my lord, I would like to place one judgment of the Gauhati High Court. Gauhati High Court, my lord. In here, in paragraph number 3, it's exact the same case, my lord. The petitioner Forest Range, paragraph number 3, my lord. Petitioner Forest Range, North Lakhimpur was arrested while he was taking bribe. There is no dispute on 1/5. The petitioner was caught red-handed at about 2:45, but the arrest memo shows that he was arrested at 8 p.m. My lord. My lord, thereafter, my lord has stated, given that it has been violated by the DK Basu case. Then, my lord, on paragraph number 9, it has stated the track memorandum, paragraph number 9, my lord. Here, in this case, the track memorandum shows the petitioner was apprehended at 2:45, while the arrest memo shows that he was arrested at 8 p.m. This is a clear violation of the guideline laid down by DK Basu. This is a clear violation of Article 21, my lord, of this constitution. A second ground is that, my lord, that it has violated the guidelines of DK Basu case, my lord. 35, paragraph number 35, subparagraph 2, my lord, to DK Basu case, which has been reiterated in this judgment, my lord. 35 paragraph, subparagraph 2, which says that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family or respectable member, and it shall be countersigned by the arrestee and shall contain the time and date of the arrest, my lord. But the arrest memo where he was apprehended on 5/12/2025, in the FI itself, if my lord may peruse the FI, in the FI it says 5/12/2025 at 11:45 a.m. he has been restrained, my lord.
No. The thing is that the time of arrest may not be the time of apprehension.
Yes,
or
I agree.
time of taking into.
But his charge sheet, I mean, his seizure list, which says at 2:25 p.m., his seizure list was given, my lord. Seizure list, I have not annexed, my lord. It's in the TCR, my lord. But my lord, thereafter he was in the police station only. He was arrested. He was in police. He was interrogated. Whatever has been done.
Maybe that may not amount to arrest.
That is one of the grounds, my lord.
Perhaps I have not remembered the citation. Perhaps in one of the case, Supreme Court has clarified what is arrest, what is detention, what is apprehension.
My lord, may I agree?
Mm.
My lord, 40 section.
So your primary contention is that
Section
section 47
has not-
BNS and 50 NDPS Act not complied with.
Section 50 and 47 BNSS has not been complied with because the basic facts of the case has not been mentioned in this section 47 notice, which ought to be mentioned as per the judgment of Prabhu Pukasta, Vivan Kumar and Mihir Rajesh, my lord. Now, my lord may have seen the Prabhu Pukasta judgment, which have been already placed on before your lordship, where there is in paragraph number 37, it says the reason of arrest. If you compare, my lord, that reason of arrest with these grounds of arrest, my lord, it is the same, my lord. But there has to be differentiate between the reason of arrest and the grounds of arrest, my lord. Now, my lord, whether now there's a third ground is that whether section 50 has been complied with or not in the NDPS case, because in the FIR itself, it says that section 50 has been complied with, but I don't think, because we have given for a certified copy, applied for a certificate, but nowhere we have found that section 50 has been complied or not, my lord. That is the question which, my lord, I'm still having a doubt.
The
my lord.
TCR is received. Have you gone through the same?
I've gone through it.
So is there any material to show compliance of section 50 of NDPS Act?
This is section 50, section 50 notice that I haven't found it along with the TCR notice, but also from the everyone also the IO, the witnesses, even the statement of the accused in one of it is BNSS, he has also stated that he was given section 50 notice perceived.
No, where is the copy then?
Where is the copy, my lord?
It was not probably it is not seen for trial.
No, on the other day, he has raised the issue. You could have confirmed it from the IO.
So one more thing.
Where is the copy?
Section 15, but that material article, the material was seized from not from his own body. It was seized from his from the back seat of the vehicle. The material was seized.
Then, my lord,
when articles were not seized from his own body, then section 50 is not required.
Not required.
Not required. That is also that one thing that many earlier it there also, and the subsequent also that state of HP versus common court. It is stated also when articles are seized, not seized from his own body, then that section 50 notice is not required. So to regarding section 50 notice, that is my submission. And regarding section 47, BNS is compliant. If you lordship kindly go to the section 47 notice lordship, it has been annexed.
Page number
31, madam.
31.
Not 28, 28. No, it's
it is not listing.
after button.
This thing one also.
It's the same, my lord.
Same also.
Same, lord.
Because of the clarity, here lordship that section 47 notice. Here ground of arrest lordship. You have been found in possession of substance to be heroin weight total 476 grams prohibited by law. One ground. For proper investigation of the offense, if custody is required. 3. C. To prevent you from causing the manner of procurement of the suspected to be heroin, which totals 476 grams, to disappear or tamper with such evidence in any manner. So this is the ground of arrest. There are the regions of arrest is also mentioned. So the ground of arrest will not be mentioned as per the requirement of the accused himself. It is the requirement why the prosecution, why the IO has arrested him. And here that is a very basic ground, because you have been found along with that much of quantity of heroin, so that your further investigation is required, so your custody is required. And thereafter it is also mentioned that so that you cannot hamper or tamper the evidences, so your custody is required. So also this is the grounds what the IO has submitted to him. So this much is sufficient, and what else ground will be there, because this is not a mini CD. in the grounds of arrest, the entire city part, entire what will happen, what will be the consequences, entire will not be there, Lordship. The simple, the 2-3 things is there sufficient, Lordship. And therefore, the reason of arrest is also there, Lordship. So, Lordship, what else it is required? I do not understand from that day also, Lordship, it was submitting it, 47 is not
No, my
not properly served, Lordship. Grounds of arrest is sufficient, Lordship. What else, Lordship? Required, Lordship.
My lord, as per the judgment of the apex court, my lord.
Yes, Lordship, that is the submitting as probable purpose. Then what my learned friend can explain that what would be the reason of arrest,
Yes,
that
my lord.
what would be the ground of arrest.
Yes, my
As
lord.
per probable purpose, in this case, Lordship.
Yes, my lord.
You can explain,
I can explain, my lord.
Explain better more than the Lordship.
My lord, I can explain.
Please,
Please.
Once the grounds of arrest is elaborately mentioned, furnished to him, Lordship, in such a way that why you have been arrested, because you are in custody of such and such number of bureau with you. Your investigation is required for the how it is, how where you have got in, and so that you cannot, your arrest is also required. Why? So that you cannot hamper or temper the evidences further. So this is the ground of arrest, Lordship. And what else? And how he is in thereafter, Lordship, because of any ground of arrest that he wants that this ground of arrest should communicate to me, and how why for that whether he is been prejudiced for any such further grounds. Because this is the ground of arrest, what the Article 22(1) says, the ground of he should know why he is being arrested. He should know that much is sufficient. That then when person is carrying himself with the narcotic substance, Lordship, and he do not know, and he is saying that now he is demanding the ground of arrest something should be more. That person cannot. This is not that he cannot demand something more elaborate ground of arrest, Lordship, because this is sufficient for him to know why he is being arrested. And that too, when the articles has been recovered from his own possession, not from other possession. That it is yet. In some cases, something should be there more, something maybe some more clarification required when some materials are recovered from another person and he is being given custody, he is being searched for, he is being arrested on the basis of some other witnesses. But no material was seized from him. Then something some more particulars may be required. Even though this is sufficient, but some more particulars may be required. But here, when persons carrying the substance with him or personally, and those were seized from him, and he knows why he is being arrested, now he cannot demand, he cannot say that some more elaborate ground of arrest I should get, Lordship, for getting my bail, Lordship. This is only Article 22(1) is not for granting bail to him. That must also thereafter also Section 15 of this Lordship that this judgment I can rely, Lordship. 2005 for SCC 350 page 350 state of HD versus Pawan Kumar para 14, 15, 27, 30. Here the Baldev Singh case is also there been discussed, Lordship. The constitution bench discussed, Lordship, that when I can read up also.
Mr. Locker, this is 115. Will I resume at 2?
Yes, ma'am.
Continue.
Also, so Lordship, Section 47 complied with to my humble submission. Thereafter, Lordship, Section 50 notice it was found for the materials were received is from the backside of the vehicle. See, so it was Section 50 notice is not very at all. And thereafter, Lordship, what my learned friend submitted Dikibas case, that the discrepancy is in arrest memo and that seizure memo, case. So Lordship has rightly pointed out here, Lordship, arrest memo at the time of arrest and time of detention may be different, Lordship. Because when he was that articles were seized from him, he was detained and he was taken into custody. But he was not arrested. And subsequently, after investigation, preliminary investigation, when it was found that yes, his custody interrogation is required, then he was arrested. The arrest memo was given and he was arrested, Lordship. So Lordship, here the DK Basu case has been referred. And the mandate of DK Basu, what is the mandate of DK Basu? DK Basu case, the mandate in two things to my understanding, Lordship. That Lordship, the arrest memo, when a person is being arrested, the arrest memo has to be furnished to him. Here in this case, the arrest memo has been furnished to him. And from the time of arrest, from the time of arrest, he has to be produced before the learned court below or the judicial magistrate, concerned judicial magistrate within 24 hours. Lordship. That is the mandate, and both that mandate has been complied with. So here in this case, Lordship, the Pihan Kumar mandate is that Lordship, he has to be furnished with written ground of arrest. That is also and 47 by 47 notice and 48 notice that has also been furnished to the relatives. So everything here in this case, Lordship, all the aspects of BNSS 47, 48, 36, everyone is compliant with Lordship. So Lordship, and the person who has been arrested, he is in custody now. So as the material seized from his is a commercial in nature, Lordship, commercial quantity. So mandate embargo of section 37 will come, Lordship. And when the independent witness who are there are 3-4 with
No,
independent witness.
Mr. Bhattakur, on Laskar,
Lordship.
you see, he has not argued the case on merit. His only contention is that this 47
And 50,
BNS
my lord.
and BNSS and 50 NDPS Act has not been complied with. That is his ground.
Lordship.
My lord, for that, I would like to give a reply to the short reply, my lord.
No, I'm not
Oh,
complete.
yes, my lord. Yes, my lord.
So Lordship, that thing, Lordship, that my sample submission, Lordship, is that Lordship, section 47 notice is complied with.
Mm.
Section 47 ground of arrest that has been complied with because the ground of arrest narrated in the section 47 notice, that is the
No,
ground
you
of
have
arrest
already shown me the relevant forwarding letter of the, no, not forwarding letter, notice given to the accused.
Lordship.
All right. Anything more?
No, Lordship. That my sample submission.
So 40, according to you, 47 is complied with
50,
and 50 is to be complied with at the end of trial.
Lordship.
And that has to be seen.
That is Lordship. And apart from that also, Lordship, even but even Lordship, that 57 section, as it is why it is that has to become considered at the end of the trial, because Lordship, at this stage, Lordship, even that article was not seized from his own possession. That the judgment I have cited before, Lordship. It is specifically said, Lordship, that when when person articles are seized from not from his own bodily position. So there Article 50, Section 50 notice is not required at all, Lordship. That is a probably that was not sent for trial, Lordship. Notice is not sent for trial, Lordship.
My lord, I would like to give a short reply with regarding the section 50 of the NDPS and section 47, my lord. But my lord, may peruse the FIR, my lord, once, my lord. My lord, may come to page number 19, my lord. Page number 19.
Yes.
You know, I would not trouble by going through the details, my lord, the vehicle itself and so. My lord, after the phone number, the independent witnesses, my lord may have it in the middle of the from 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Yes.
12th line, ma'am. The independents were issued notice under section 1034 of BNSA to witness the search process. As per the legal procedure of section, notice 50 was also issued to the concerned apprehended accused person, Sadiqul Islam, so and so by the complainant for conducting the body search, my lord. My lord may have this word, for conducting the body search, the accused person was given the option that whether he would like to take to so and so. And my lord, on the next page, my lord, again section 50 has been mentioned, my lord. Now I'm agreeable to the argument.
From where the contraband substances were recovered?
It was recovered from the
vehicle.
Then? But the body was searched of the accused person, my lord. And where is the section 50 for that, my lord? Nowhere in the grounds of arrest is also mentioned there, my lord. Now, my lord, my humble submission is that it's a strong ground for bail, my lord, because there is no section 50 of NDPS Act, my lord. Now, my lord, for section 47, what my learned friend has argued that it's everything has been mentioned, my lord. But my lord may come to the judgment of Prabhu Custer, at page number, my lord.
No, you have already referred to
My lord,
that.
just one for paragraph of 48, my lord, once, my lord. Permit to custom, my lord. Before that, my lord, I would like to take to paragraph number 37, my lord.
Paragraph number?
37, my lord.
Hmm.
My lord, may see the reasons of arrest, my lord, here. And my lord, may compare these reasons of arrest with the grounds of arrest and the reason of arrest, which is mentioned in section 47, which is page number 28, my lord. Apart from the you have been found in the position of suspected heroine of weight so and so, rest everything is same as mentioned in this judgment in paragraph number 37, my lord.
What's wrong with that?
But my lord, that's what it's a reason of arrest and the grounds of arrest. My lord, now the reason of arrest and grounds of arrest has been mentioned in paragraph number 48 simultaneously in that judgment, which may be reiterated as. My lord may have the paragraph 48. It may be reiterated at the cost of repetition that there is a significant difference in the phrase of reason of arrest and the grounds of arrest. The reason of arrest is indicated in the arrest memo are purely formal parameters to prevent the accused person from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of an offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such fact to the court or to investigation of it. The reason would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such detail in hands of the investigation officer which necessitate the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts, my lord, all basic facts which he has been arrested so as to provide him an opportunity of defending himself against the custodial remand and seek bail, my lord. The grounds of arrest would invariably be personal to the accused, cannot be equated with the reason of arrest, which are general in nature. Well, whatever
No,
it
if
is,
the ground is no more ground is there, from where the IO will generate the same.
no, the basic facts has to be mentioned, my lord. How many, whether section 50 has been given, how many total soap boxes has been recovered. Everything has to be mentioned, my lord.
Heard Mr. Bogo, learned counsel for the petitioner. Is there a law for learned additional duty for the respondent? Raise the matter on Monday for further consideration. But on that day, we'll pass the order. Though we fix the matter on Monday, we pass the order on that day.
Monday, my lord, we pass the order, my lord.
Yes.
In this case, lordship, TCR was called for lordship. In the last occasion, lordship.
Lordship, before my brother are good, lordship, on merit, lordship, I have an objection on lordship on technical ground, lordship. What Here technical ground? here this application is not complied with lordship with notification number notification dated 4/12/2025, lordship, wherein the applicant have to lordship mention their lordship criminal antecedent, lordship. In this application, nowhere it was mentioned, lordship. 4/12. So this is the 4/12/2025, lordship. That's notification was sent. What is the requirement of that notification? Lordship, in every bail application, lordship, may I read the lordship operating portion of lordship? Yes. It was incorporated in the rule 7.b, lordship. Yes. In every application for bail presented to the High Court, the petitioner shall, whether similar application has or has not been made to Supreme Court, and if made, shall state the result thereof. The petitioner applicant shall also mention whether he, she was involved in any criminal cases or not.
If yes, particular and decision thereof. An application which does not contain this information shall be placed before the bench with the necessary information, Lordship.
No any communications,
Uh,
Lordship.
This
any communication. This is the case,
notification issued after the passing of Kaushal Singh versus State of Rajasthan, Lordship, by the FX Court, Lordship.
There is
So
no any
this
record of the
bill-
criminal cases, Lordship. Only these cases implicate, Lordship. And everything that, Lordship, my submission on the thing is that the length of the detention, Lordship, the pending institution, Lordship, this is 4 years and 113 days, Lordship. I was last filing the bill application last on 22, that is after last 3 years ago, Lordship. After that, Lordship, please, Lordship, the last reject order, Lordship. Give a look, Lordship. Last reject order, Lordship. Clearly, it was mentioned there, Lordship. The trial should be had finished as soon as possible, and 309/1 section should be also, they are giving the reference of that also there, Lordship. But till date, Lordship, 3 years, Lordship. 3 years, Lordship. Even 3 years, Lordship. Now also the case is on the same status, that is having the witness is the, Lordship. Near about 4 or 5 witnesses till wait, Lordship. And it seems very clear that, Lordship, it will take 1 and more years, Lordship. My submission on basis of that, Lordship. Last 3 years, Lordship, I filed the bail application. And another bail application, Lordship, at the initial part of.
Mr. Dubey, you say these facts are to be incorporated in the application itself.
Exactly, Lordship.
You see this notification?
This is a mandatory provision, Lordship. Notified by on our High Court, Lordship. And Lordship, in the course title also Lordship, provision was wrongly mentioned as section 480 of the Bharatian BNSS, Lordship. File under wrong provision also, Lordship. It should be 483, Lordship.
Lordship, in my affidavit, Lordship, I mentioned these things only, that Lordship, no
Where?
case is pending in any other case, but I'm not mentioning the Supreme Court, Lordship. In my affidavit, I mentioned that, Lordship, in paragraph number 2, Lordship.
Affidavit.
Yes, Lordship. And my petition also there, Lordship, paragraph number 25.
So you say
Lordship,
this
25 and
notification was issued.
Lordship is of Lordship filing of bail application only, not any criminal antecedent, Lordship.
Mr. Dubey, you see this notification was issued pursuant to the direction issued by Supreme Court in case of Kaushal Singh versus State of Rajasthan. So there is a direction of the Supreme Court. Better you file an additional affidavit here, incorporating the facts required to be incorporated in the petition. We'll fix it very shortly, right?
Yes, yes.
Can you file it on next Wednesday or Tuesday?
Lordship, I will file the additional affidavit, Lordship. Additional affidavit, Lordship, possible. Bless, Lordship, I will file it.
Okay. Heard Mr. Dubey, learned counsel for the petitioner, Mr. So learned PP for the state respondent. The learned PP has drawn the attention of this court drawing attention of this court to the notification dated 2nd of December 2025, submits that this application has not been filed pursuant to the rule 7B of Gauhati High Court. Gauhati High Court rules. And he also pointed it out that this application is also filed under wrong provision of law, that is section 480 of the BNSS 2025. Mr. Dubey, learned counsel for the applicant, submits that he may be granted some time to file amended cause title. You file amended cause title. Amended petition. Amended petition incorporating the rule, incorporating the requirements as provided in the rule 7B of the Gauhati High Court rules. RSSL is the matter on Wednesday.
Wednesday. Ali blessed also.
Definitely.
Standing item 49.
Tabesh? Okay, sir. Amicus. Pardon, sir. Learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. Mr. Sharma has apprised this court that notice upon respondent number 2 has been served, but no one entered appearance. In that view of the matter, one. She was already engaged. New counsel, Angaj Gautam. A. Gautam. Angaj Gautam. Angaj Gautam be appointed as amicus to represent the case of respondent number 2. To represent the respondent number 2. Basis shall reflect the name of Mr. Angaj Gautam in the cause list and also furnish the relevant papers well in advance. List the matter on 6 August. Sorry. 6 August. Fifty. The 15 is good. Okay.
May I please?
Yes.
Here in this case, the petitioner before your lordship is in jail since 14/2/26. 14/2/26. As on today, 168 days.
14/2/26. Okay.
168 days as on today. Now, in terms of FIR at page 201, I am reading the vernacular. I find English translation is not up to the mark, man. So your lordship kindly peruse page 20.
Under section 6 is also there, Pakshar. Okay.
20.
Yes.
This is the FIR. May I read?
No, not necessarily whether section 6 is made out or
Yes.
not.
On the basis of, my lord, along with some sections of BNS, section 6 has been incorporated. Now, your lordship kindly peruse page 2-3. After that, the petitioner was reason of arrest. I not got it, page 23. I not got it. Reason of arrest. Here, my lord, 4 reasons has been cited.
A, if not arrested, 4 or 5? 5. If not arrested, accused might commit such offense again in future. Number 1. B, arrested for proper investigation. Arrested to prevent him from causing evidence of offense to disappear. Has been arrested to prevent him from making any inducement or threat. And unless arrested, the present court, whenever required, he cannot be ensured. So far, A and E is concerned. I have made a statement on oath under any condition. Your Lordship, if allows, I will abide by that undertaking I have given in my application. Now, so far, B, C, and D, that have already been eliminated because evidence, the investigation completed, and evidence of informant and victim has been recorded. Informant and victim. Yes. Victim as PW2, informant as PW1 are examined. So the reason of arrest as regards B, C, and D already eliminated. Am I clear? It is clear, but how it is relevant now? Yes, my lord. Now it is only government, my lord, pleasure to book me behind bar, my lord. So far there is no third perception, it is gone. Inducement of witnesses gone. Now I am behind bar for 168 days. So except government pleasure, my lord. Your play is this period of detention. Yes. Period of detention and reasons when I was arrested, 5 reasons cited. As regards to, I have said, my lord, I have made a statement on oath that any condition, if your lordship, I will not.
Oh,
No,
whether the reason of arrest is now relevant.
that is why, my lord. Then there was a apprehension that I can, there is a possibility that I may induce the evidence, I may hamper the investigation. All are gone. Investigation completed. Witnesses, PW1 and 2, victim and the informant recorded. Now there is no, these such things are not.
No. Is there only 2 witnesses, the victim and the informant? Is there no other witnesses?
Always in a case of POCSO or sexual offense, whatever may be, the victim is the prime witness. So this is one part of my argument. Now the subsequent part, the second part. If this is the first part of the length and 3 reasons has already been eliminated, so there is no justifiable reason to book me in custody for further period. This is my first limb of argument. Am I clear? Now the second limb, 2 witnesses examined. Your Lordship, I have annexed the deposition. Both informant and the victim turn hostile. They are put to cross-examination by the prosecution. Nothing. Your Lordship, for a moment, kindly peruse the deposition of PW1, that is informant. Page 30. I am informant. I am informant in this case. My daughter, I know the accused, present petitioner before your Lordship. Incident occurred about 3 months ago. Result.
May I please, Lordship, accused number 2 and accused number charge sheet is in charge sheet. My name is not mentioned.
Equity number 1.
I am the brother-in-law of accused number 1.
Against the present applicant, no search sheet is submitted.
That report is good. Only one against Rafiqul Islam has been submitted, and he is absconded. He is being shown as absconded.
So we are closing this application then.
That's it.
We are closing this petition.
That may be a record.
Okay, heard. Mr. Your name?
Tiyuddin.
Learned counsel appearing on behalf of Mr. S. Ahmed.
S. Ahmed.
Learned counsel for the applicant and Mr. P. S. Law for learned additional fee for the state respondent. Person to order dated 28/7/2026, Mr. Lawford has produced one WT message of Inspector of Police Officer in search, Masters or PS of District Boingao. And on the basis of the said message, he submits that search sheet has been submitted against one Rafiqul Islam, who is presently absconding under section 137 to BNS, read with section 6 of the POCSO Act, read with section P, PCM Act, and PCM Act. And it appears that the present applicant has not been search sheeted. Since he has not been search sheeted, the apprehension of arrest does not arise, and as such, the apprehension of arrest ceases to exist. And in that way of the matter, this application become infructuous, and accordingly the same stands closed. Interim order passed earlier stands cancelled. The WT message produced before this court shall be marked as Annexure X and be tagged to the record.
May please, Lordship. Lordship, here the petitioner was on interim bail, Lordship, and he has pursuant to the interim bail, he has appeared before the IO, Lordship. The FIR, Lordship, will find at page 10, Lordship.
CD has been received.
Although in the IO statement, I will note whether it is written that he has appeared for the after interim, but his statement is not available in the record balance. In the IO note, it is written that he appeared after interim.
When you appeared before the IO?
Exactly, I could not say. After taking the interim order from me, Lordship, he has appeared. He informed me, Lordship.
One year, 17/7. In the 17/7 in IO note, it is said that he has after getting interim from the honorable court, he has appeared and statement also recorded, but his statement is not available in the record, but otherwise he has appeared.
Lordship, the allegations, Lordship, has already read. Although these allegations are of March, Lordship, FIR was lodged in July, Lordship. And this FIR has been lodged at the behest of this wife of this petitioner, Lordship, who is the principal of a college, Lordship. And that relation between this petitioner and his wife is not cordial, Lordship. Yes, if you, Lordship, will read the FIR from 16/12/25 to March, he was in that house. But no such allegation, Lordship. After she went out of the house in March, the allegation, Lordship. Now, what is there in the CD? I don't know.
Whether the statement of the victim is recorded?
As per my IO note, 17/7.
Recorded.
Recorded. And it's 10, but I have not found in the record.
in the last plague, my lord. Last plague. Last, my lord, I will move to the my lord. In this plague, my lord. Yes, look, my lord. What else?
So he's already on bail.
My lord, intelligent, my lord.
So let him remain.
But otherwise, 183, my lord, statement is categorically indicated.
We'll cooperate lordship with the investigation.
Hmm.
If charge sheeted lordship, then I'll cooperate with trial also.
But the problem is that he has been threatening her.
My lord, third part, my lord.
Even the FIR lordship was lodged after 4 months lordship.
Maybe
But no, even no explanation is there why that delay is caused.
that is a matter of trial.
And it's not that she is an illiterate girl lordship. She says that she is.
He has
qualifying to
threatened to kill her and her brother.
Well, these are just allegations, lordship,
Allegation.
because nothing has happened of that sort, lordship.
Nothing has happened.
Hmm.
But a medical report was collected.
No, my lord, medical report. No.
Medical set. কেনেকে হ'ব ছাৰ?
So medical examination refused.
No.
What to do then? Heard Mr.
Emma.
Ahmed, learned counsel for the applicant. Mr. B. Sharma, learned additional counsel for the state respondent. Person to order dated 15/7/2026. Mr. Sharma has produced the case diary before this court. And on the basis of the materials collected so far in the case diary, Mr. Sharma has contended to dismiss the petition. As in the statement under section 180 and 183 of the BNSS 2023, the victim has clearly implicated the accused with the offense alleged in the FIR. And Mr. Ahmed, learned counsel for the applicant, submits that person to order dated 15/7/2026, the applicant had appeared before the IO, and his statement is also recorded. And he will cooperate with the investigating agency, and therefore it is contended to make the interim order dated 15/7/2023 absolute in the same terms and conditions. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. B. Sharma, learned additional PP. It appears that the IU has collected some materials against the present applicant, and the investigation of the case is also progressed significantly. He has already been granted the privilege of PRS bail by this court, by a coordinate bench of this court by order dated 15/7/2026. And there is no allegation of misusing the liberty granted to him by order dated 15/7/2026. Moreover, the victim has refused medical examination. Thus, considering the progress of investigation, and also considering the fact that the applicant has extended cooperation with the investigating agency, his custodial interrogation seems to be not warranted here in this case, and accordingly, the interim order dated 15/7/2026 is hereby made absolute in the same terms and conditions. CDB returned.
I'm obliged.
46. Sir.
36 wala charge sheet submitted. I am on, we are on interim mail.
What are the sections?
The cattle resolve.
So you go and apply for regular bail there?
Yes.
Heard Mr. Yayuddin, learned counsel for the applicant, and Mr. B. Sharma, learned additional PP, learned, no, for the state respondent. It is submitted at the bar that after completion of investigation, the IO has laid charge sheet.
Charge sheet number 72 of 26 and then 24/7
against the present applicants. And in that view of the matter, this court is inclined to dispose of this application by directing the applicants to appear before the learned trial court on or before 21st of August, and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, interim order dated 15/7/2026 stands extended.
I am obliged.
CDB.
Everything. TD was called for.
Number 37.
Received. Section 42 and 10 of the UPA for accepted basis as per 53 of the UPA is not maintained. And my lord, regarding the present, there are also some there are 3 cases,
matters relating to the stone mining, illegal stone mining in Doyang, Bharmela, Nagaland, and Assam. And if there are materials against all the accused persons for some other cases, it's some,
No, in UAP Act, this anticipatory bail application is not maintainable.
it will not maintainable. 43D4 of the
43D.
43D4. Nothing in section 438 of the judicial apply in relation to any case involving the arrest of any person accused of having committed an offense punishable under this. So in case of any offense, under the anticipated bail is not maintained. Petitioners are in interim, thereafter pending materials later on you will give.
Yes, that Rahman. I am on interim earlier.
You are an interim, but when this UAPA Act is added?
Added on
The subsequent.
by order dated 24/7/26.
24/7/26. So what to do? You want to withdraw this petition or will dismiss it?
No, withdraw.
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 Pardon me, sir.
Ziat Rahman on behalf of Zay Ahmed.
Your lordship may record that this petition is not maintainable in view of
Okay.
addition of offense under you.
Learned counsel appearing on behalf of Mr.
Zay Ahmed.
J. Ahmed, learned counsel for the applicant. And also heard Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that by the order dated 24/7/2026, the learned which court?
Yes, my lord. Your lordship. First class Bonsri,
Judicial Magistrate First Class Bonsiri has allowed has edit section
section my lord 42, 40 my lord in bracket 2 and section 10A of the small a of the
40 within bracket 2.
Yes.
Edit section 40 within bracket 2 and 10A of the Unlawful Activities Prevention Act 1967. 67 and referring to section 43 D 43 capital D within bracket 4. Mr. Borthakur submits that nothing in section 438 of the code shall apply in relation to any case involving the arrest of any person accused of having committed an offense punishable under the UAPA Act. And as such, he submits that this application is not maintainable and therefore the same may be dismissed. At this instance, the learned counsel for the applicant submits that he may be allowed to withdraw this application. Accordingly, taking note of the submission of learned counsel for both the parties, the learned counsel for the applicant is allowed to withdraw this application. In view of above, the interim
15
order
15/7.
dated 15/7/2026 passed in this application stands recalled.
Hello.
Item 39.
Mr. Borthakur has produced one copy of the order dated 24/7/2026 passed by the London Judicial Magistrate First Class Dhansiri. The same shall be tagged with the record.
My lord, that a copy I will have from my lord.
Yes, Xerox copy you can obtain. Yes.
My thing is complaint case was filed, my lord. Complaint, you also will find the complaint at page 16, my lord. As per the complaint, my lord, the petitioner number 1 and informant got introduced through Facebook, my lord. And the day it became, my lord, romantic affairs were started, my lord. Both of them. And they developed some.
And the applicant number 2 is the mother and applicant number 3 is the father
Of the applicant number 1, my lord.
assaulted and abused her. Abused the informant. Abused the informant in their house. The learned counsel for the applicant submits that this court by the order dated 28/7/2026 was pleased to grant the privilege of interim PRS bail to the applicant number 2 and 3. And accordingly, they have appeared before the IO and their statement are also statements have also been recorded by the IO and they are cooperating with the investigating agency and therefore he has contended to make the interim order dated 28/7/2026 absolute in the same terms and condition. In respect of applicant number 1, the learned counsel for the applicant submits that there was a relation between the applicant number 1 with the informant and though there was a relationship between the informant and the applicant, subsequently the same discord surfaced between them and thereafter the informant has lodged the FIR against the applicants and the applicant number 1 is ready to cooperate with the investigating agency and therefore it is contended to allow the application. Per contra, Mr. Parthakur learned additional PP has produced the case before this court and submits that though custodial interrogation of the applicant number 2 and 3 may not be required yet. It submits that the IO has collected sufficient incriminating materials against the applicant number 1, and also the applicant has implicated the informant has implicated the applicant number 1 in her statement under section 183 of the BNSS 2023, and under such circumstances he is contented to dismiss the pair in respect of applicant number 1. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents placed on the record, and also perused the case diary with the assistance of Mr. Borthakur, learned additional plea. In view of the materials collected so far in the applicant number 2 and 3, and in view of the cooperation being extended by them with the investigating agency, this court is of the view that their custodial interrogation may not be required in the interest of investigation, and accordingly the interim order dated 28/7/2026, so far it relates to the applicant number 2 and 3 are concerned, is hereby made absolute in the same terms and conditions. However, in view of the materials collected so far in the case diary, especially the statement of the victim girl recorded under section 183 of the BNSS 2023, and also considering the nature and gravity of the offense, this court is of the view that this is not a fit case to grant the privilege of 3 years bail to the applicant number 1. Accordingly, the petition so far it relates to applicant number 1 stands dismissed. Case diary be returned. All right.
Number 40, my lord, case diary not received.
I'm not sure.
Part Miss
Bidas.
learned counsel for the applicant.
Interim may continue, Lordship.
Mr. Borthakur, learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Borthakur shall produce the case diary before this court on 17/8. Till then, interim order passed earlier shall continue.
Lordship, item 53 in supplementary list, both are analogous matter, Lordship.
There also, you are on interim bail.
Yeah.
50?
Not in interim, not there, Lordship.
53.
53. No.
Okay, Mr. Borthakur shall produce the case diary before this court on same day.
42. It is a lordship, a regular bail application. The TCR was called for, my lord.
TCR received, Lordship.
My lord. The FIR is at page 15, my lord. With due respect, I would like to inform you that I am a resident of so-and-so. I am residing with my old age mother and 17-year-old daughter. Some of my neighbors have been repeatedly harassing me for a long time. The harassment upon our family seems to be increasing day by day. Yesterday at about 10:45 p.m. while I was standing in front of my gate, Shahjahan Choudhury, the applicant, without any reason started abusing me with slang language. He even threatened me that like Kashmiri Hindu people, he'll throw me out of the house and beat me to death like the Kashmiri Pahalgam incident and West Bengal incident. Hearing these slang languages and comments which cannot even be written, I asked him not to repeat these things, otherwise I'll give complaint against you. Then Shahjahan came near me and physically assaulted me. He even tore and pulled on my t-shirt.
May I please, Lordship? Well, this is a non-FIR case, Lordship. The petitioner is apprehending arrest. Well, a report was called for the police, Lordship. Police report? Non-FIR case. Well, there are two in the petition, Lordship. I have stated why you have preferred this petition, Lordship.
The last, we have received one report, Lordship, the last paragraph, Lordship. It is respectfully submitted that the matter is presently under inquiry in exercise of the powers conferred under the BNSS. Since the inquiry is still in progress and no formal police case has yet been registered, no case diary has been opened or maintained as on date. Consequently, the case diary could not be produced before a court. So as on date, no case has been registered.
So what is the question of apprehension?
But with that observation, your lordship may close. Because of my father was picked up, lordship, and pressurized him to produce me. Lordship, subsequently, the petitioner father failed to produce the petitioner.
That report is available also. Heard Mr. Khan, learned counsel for the applicant, Mr. P.S. Lawford, learned additional PP for the state respondent.
But father of the petitioner also approached before this court, lordship. This order was passed.
No case has been filed, no case registered.
But police is frequently, lordship, visiting to arrest the petitioner. That is.
This application under section, no, this application is preferred by Kamran Akmol Laskar, apprehending arrest in connection with non-FIR case. Non-FIR case. And this court by the order dated 24/6/2026 directed the learned additional PP to call to obtain a report as to directed to call for a report from the Lala police station as to whether any case has been registered against the present applicant or not. And accordingly, Mr. Locker learned additional PP has procured one report dated 26/7/2026, and perusal of the report indicates that no case has been registered against the present applicant till date. Whether they received any FIR?
FIR is.
Though one FIR has been received and entered into the Zenel diary by Lala PSGD entry number 17 dated 14/6/2026. And entrusted to one SI Zainal Abedin Choudhury for conducting preliminary inquiry. At an early date as to whether the allegation discloses the commission of a cognizable offense or were predominantly of a civil nature. And that inquiry is still going on. And formal police case has not yet been registered and no case diary has been opened or maintained as on date. It is to be noted here that the FIR was lodged on 14/6/2026 by one Zainal Abedin Khan. That Kamran Akmol Laskar and his father Salimuddin Laskar induced him to invest a sum of rupees 78 lakhs in a business transaction on the assurance that the principal amount along with business profit would be returned. And believing their representation, the informant entrusted the said amount to them. And subsequently, despite repeated demand and requests, the accused persons failed and refused to return the money. And according to the informant, they have dishonestly misappropriated the entrusted amount and cheated him, and thereby caused substantial loss and mental harassment. Fed In view of the allegation in the FIR dated 14/6/2026, as is apparent from the report of the officer in search, Lala Police Station dated 26/7/2026. This court is inclined to grant the privilege of peerless bail to the applicant, as at this stage it cannot be said that there is no apprehension of arrest, though no case has been registered till date. Accordingly, it is provided that in the event of arrest of the applicant in connection with the FIR dated 14/6/2026 lodged by one Joinal Abedin Khan, the applicant herein shall be released on peerless bail on his executing a bond of ₹20,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. The three conditions. In terms of above, this AB stands disclosure.
Obliged.
The report produced before the court today shall be part of the record.
Items for admission, item 21.
May I place it? No, the petition has been filed challenging the criminal proceeding instituted against the petitioner, my lord, in an enact case, my lord. Complaint, my lord, will find at page 14. 1/4. Two accused persons have been arraigned, my lord. Accused number one is not. Accused number two is before your lordship, my lord. Accused number two is the wife of the accused number one. Now, going through the complaint, my lord will find that the checks was issued by the accused number one, and the agreement also was entered with the complainant and the accused number one. The bank account belongs to accused number one, my lord. Accused number two is the wife of the accused number one, my lord. She have not issued any check against the complainant. She has not entered into any agreement with the complainant, my lord.
Who issued the check?
Accused number one, the husband of the petitioner.
And who preferred this application?
The wife, accused number two.
So
Cognizance has
check was not issued by her.
no. The bank account belongs to the accused number one. There was an agreement between the complainant and the accused number one, not accused number two. That agreement is there in the records, my lord. They have entered into agreement with the accused number one, but cognized and they have arraigned.
No, whether there is any company in their name?
No, no, no.
Nothing.
She cannot be held vicariously liable, my lord, in an enact case.
No, that's all right.
Yes.
Whether they are partners of a
no,
partnership
not-
firm or any proprietorship firm.
No, no. Man. Even if they had, the complainant then has to arraign the partnership firm or the company. That is not there. In the complaint
Not
only.
there.
No,
Nothing.
nothing.
So whether the check is part of the record?
Well, it is there in the records, my lord. Records
Original record.
Yes.
So why the accused number 2 is arrayed as a party here?
Lordship, my direct friend had mentioned about the lordship, the compromise agreement lordship. Continue,
No, no. Of course, yeah, section 420 is also there.
420 is there.
That's why, lordship. I am trying to get
No, 420, my lord is aware, my lord, their intention has to be right from the beginning. Now, the agreement that has been entered into by, with the complainant and the accused number 1. So, well, the intention for cheating cannot be on the wife, my lord. Neither, the wife did not enter into any
Agreement.
No,
She has not entered into any agreement. Whether that agreement is part of the record?
no, my lord, that is in the records, it is available in the records.
You please go through the record and mark the agreement, mark the check. We will hear it on some other day. Mr. Munir, learned counsel for the petitioner, Mr. Learned counsel for the respondent. Hardin part lays the matter on Tuesday. Next Tuesday.
There's interim order that may be continued. There is an interim order that may be.
Interim order, if any, shall continue. Item number?
23.
None appears for the petitioner on call, lays the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. Next.
One of correction list for admission. Presentation, I told you.
May I please, your lordships? In my application submitted with the court below, it was rejected, my lord. My vehicle, that is my motorcycle, was seized on 23/8/2025, and since then it is under the custody of police station, lordships, and open sky, and damaging all the parts, exposed, then decaying the parts of the motorcycle, my lord. The impugned order is at page 23. I am the registered owner of the vehicle, lordships. Page 20, the last way. Prejudice here, including orders dated so and so so and so. No report is submitted by the prosecution on the pending petition number so and so filed with the accused person seeking custody. of the
So whether this vehicle is involved with the offense alleged?
My lord, that actually there is, it was found in the vehicle.
Found in the
In the one packet is found in the
Vehicle.
motorcycle handle. And on that count, petitioner was also arrested. He was nearby shop of the shop, lordship, standing in the shop.
and
That police came.
and what is this? That proceeding is pending?
Proceeding is the evidence stage, lordship.
Evidence is this.
That records received, lordship.
So why the trial court will release the same so that you can use it again in commission of the
Yes,
offense?
at any time I will place, lordship, whatever required, any condition, lordship, I will place my only that
No,
motorcycle.
where is the guarantee that you will not use the same for commission of the any other offense
Yes,
or repeat the same offense?
my lord, no, not in the mobile phone also there is that reflect that there is no offense also. If he has committed or is involved, no mobile only reflect there is a commission of offense also. Lordship order itself reflect. In the page 20, lordship, the record nowhere shows that seized mobile phone was used for commission of the alleged offense. However, it is clear that the seized motorcycle was used for transporting concerned contraband. On that packet was found the handle of the motorcycle. That's why, lordship. And my motorcycle used, but I was victim of circumstances because of one of my friend called me.
In the impugned order, it is clearly reflected that the motorcycle was used for transporting the concerned contraband.
But lordships, even if there is no bar in the independence case, there is no bar.
in the NDPS case regarding release of vehicle interim custody. I am placing the judgment of the FS Court lawsuit. Will see in paragraph in the NDPS case lawsuits in the case of Abhijit Vishwajit, the state of Assam, to the 25 3SCC, that is release of vehicle interim custody. I am placing lawsuit. Paragraph number 38 lawsuits. 38 and 40. This court is also of the view that if the vehicle in the present case is allowed to be kept in the custody of police till the trial is over, it will serve no purpose. This court takes judicial notice that vehicles in police custody are stored in the open. Consequently, if the vehicle is not released during the trial, it will be wasted and suffering the vagaries of weather, its value will only reduce. On the contrary, if the vehicle in question is released, it would be beneficial to the owner, who would be able to earn his livelihood, to the bank financer, who would be repaid the loan disbursed by it, and to society at large, as a condition vehicle would be available for transporting goods. Consequently, the present criminal appeal is allowed with direction to trial court to release the vehicle in question in the interim on supervisory after preparing a video and still photographs of the vehicle and after obtaining all information documents necessary for identification of the vehicle, which shall be authenticated by the investigating officer, owner of the vehicle, and accused by signing the same. Further, the appellant shall not sell or part with it ownership of the vehicle till conclusion of the trial, and shall furnish an undertaking to the trial court, and he shall surrender his vehicle within 1 week of being so directed, and pay the value of the vehicle determined according to income tax law on the date of release. So, if ultimately directed by the court. Even court paragraph 26, 27 also similar things reflected lawsuit. This court is further of the paragraph 26 lawsuit reflected. This court is further the opinion that there is no specific bar restriction under the provisions and this act for return of any seized vehicle used for transporting narcotic drug or psychotic substance in the interim pending disposal of criminals. That finding is recorded in the page 38, paragraph 38, 39. My lord, I am victim of circumstantial losses. Called my one friend to drop him, and he kept it his bag. It is my vehicle is my motorcycle is for dropping and lifting of my child the school to tuition. And I am a businessman by having mobile repairing shop at Hailakandi town. And my residence is near the Hailakandi town, and that is in front of my house. One friend called me on that day. And the records also shows no case, nothing else.
Okay, Mr. Boisha, what is your contention?
My lord, on the same, the authority which is relied by my senior colleague, my lord. I once again go through that. Only, my lord, here a question when, my lord, the team order, my lord. While it is reflecting, my lord, it is stated, my lord, that it is clear that the said motorcycle was used for transporting a contraband, and hence the vehicle may be required in the course of confiscation unless such proceeding has already been initiated or concluded. Now, my lord, here, my lord, it, my lord, can use the, my lord, FIR, my lord. In, my lord, page 12, my lord, it is started an exam 1, my lord. My lord, the next, last line of the, my lord, the same page, we arrived at 31 bypass road, 06 at 9:30. As per the course input, conducted Nakasiping near the Gauhati bridge, and during Nakasiping detained one suspected, namely Warslum along Borneo. So, my lord, here, my lord, when my lord apprehended, that is my one, my lord, that is the present accused petitioner, my lord. So and so, son of so and so, resident of so and so, carrying narcotic substances on his bike. So, my lord, only on that point. Otherwise, my lord, law settling, my lord, Sundar Bhai Ambala Desai is, my lord, that part is, my lord, very clear, my lord. Having, my lord, friend guarantee or, my lord, the board, that can be given. Only, my lord, that part, whether, my lord, it is, my lord, succeeded case, and that particular vehicle is, my lord, used, my lord. So my lord, on that point only, I would like to go through my lord, regarding that authority only, my lord, this part, my lord. Otherwise, law is set up, my lord. If my lord, the
So
owner
today
is-
you are not ready to argue the matter.
my lord, only that point. Otherwise, my lord, that part is clear, my lord. Right now, I
Let it
don't
be
have the
on
authority, my
on Thursday next.
lord. My lord.
Heard Mr. Barbuya, learned counsel for the petitioner, and also heard Mr. Busto, learned additional for the state respondent. Heard in part, place the matter on Thursday.
My lord.
Instead of 6th of August, prior to that, Lucy. On 4th of August, I have so many cases on that day also. That's difficult.
Maybe.
Friday, Thursday.
May it please your lordship, I hope I could join in.
Yes.
Yes, in this matter, may it please your lordship, and for the petitioner, in this matter, my preliminary objection to the FIR and the proceedings is that the entire proceedings alleged offense has occurred in West Bengal, Kolkata. Nowhere in the FIR it at all says it is any part of it is in anywhere else in India. Now, section 197 is an absolute bar to that in the BNSS, your lordship. So that is one objection on a point of law. And the other one is section 223(1). Cognizance was taken without any notice being issued, which is a mandatory requirement of law. So these are the points, your lordship, on which this proceedings needs to be quashed, especially section 197. There is a judgment. I will not trouble your lordship perhaps with the judgment at this stage, which is also there. It is there. Learned advocate may hand it over to the court if need be. It is on the point of 223(1), where the notice is absolutely mandatory. And in these grounds, your lordship, this application is to be heard out or allowed.
Okay, today let notice go.
Yes, your lordship. Yes.
We'll call for the record.
Yes, lordship.
Is there any
And
interim prayer?
yes, stay of the proceedings in the interim, your
Okay,
lordship.
on a receipt of the record, we will consider your prayer. Heard, Mr. Your name, please.
Krishnendu Guptu.
Learned counsel for the petitioner. This petition under section 528 of the BNSS 2023 is preferred by the petitioner for quashing the proceeding, criminal proceeding in serial case number 579 of 2025 under section 303, 62 and 3 within bracket 5 of the BNS 2023 pending before the Court of Learned Civil Judge Junior Division number 5. JMFC Kamrup M Gauhati. The learned counsel for the petitioner submits that this petition, no, the complaint case before lodged before the learned trial court is not at all maintainable as because of the bar under section 197 as no cause of action arose within the jurisdiction of the learned trial court. And secondly, he pointed it out that no notice under section 223 within bracket 1 of the BNSS 2023 has been issued. The submission of Mr. So-and-so learned counsel for the petitioner needs further consideration at this stage. Notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Registry shall call for the record from the learned court below. Scan copy of the record from the learned court below. Interim pair of the petitioner will be considered on next date on receipt of the record. List after 4 weeks.
Lordship, deeply obliged, your lordship, deeply obliged.
Return to a production list. In a 15326. Otherwise, in this matter, here, lost by the assistant commissioner of the state tax method. Earlier in this case, so in some of the cases, serious economic offense, but getting registered under the special task force police station, more than crores of rupees by getting.
Who will appear? Gogo will appear. When?
All for the city today.
CD.
City case.
Okay. Heard, Mr.
Your lordship,
Okay.
Terry, your lordship.
Learned counsel for the
Your lordship, the method may be fixed on 3, your lordship.
accused.
In your lordship,
And also heard Mr. Borthakur learned additional PP for the state respondent.
your lordship, if I may, your lordship, this morning I was also trying to mention 2 more items, your lordship, on some same subject matter, your lordship, and say for that same CD may be required for calling, your lordship. So if both the application
No, in the
institution is
morning we have not allowed to
yes,
mention
yes,
those
yes,
two
yes,
items.
true, your lordship,
Then-
true, your lordship.
This application under section 483 of the BNSS 2023 is preferred by the accused, namely Ajoy Kumar Jadhav, who has been languishing in jail in connection with special task force within bracket STF PS case number 2 of 2026 under section 16 within 61 within bracket 2, 318 within bracket 3, 319 within bracket 2, 336 within bracket 3, 338 struck 340 within bracket 2 of BNSS 2023. Who has been languishing in jail since 15/6/2023. Where is the petition and the documents passed on record? After hearing learned counsel for both the parties, it is provided that Mr. Borthakur shall produce the case diary before this court on
On my lord,
No, your lordship,
10 not 12.
your lordship, 10, your lordship, 10. Your lordship, my senior, Mr. M. Carter will be traveling, your lordship. So 10 will be your lordship.
Monday, otherwise, only earlier than Sunday, so finally on 12. The rest of the days on 12 method would be convenient for us to get the thing.
no, the conducting counsel will be coming from
Arunachal Pradesh, your lordship.
Arunachal Pradesh. So can he not come on 13?
13, your lordship, I'm quite not given instructions, but as far as it, your lordship, I think he has made all his.
Okay, STF PS is here in Gauhati.
Yes. Otherwise, we will also have to go through the entire series because.
You call for it.
Earlier than Sunday.
Okay, let it be on
10, your lordship.
10. Okay, 10.
As obliged.
Lordship, in item number 23, my item was left.
Yes.
But I was not present. I was called by my senior due to the bail application on it. So my date may be fixed on it.
Sorry. After 1 week, 1 day. Take a date from
My
Okay.
present maybe marked.
record is.
Deeply obliged.